It's Meg McGrath-Smith. I'm the Ward 7 City Councilor, and I am the Chair of Charter and Rules. We're going to begin this meeting, which is Wednesday, April 2nd, 2025 at 6:30 p.m. To my left is Councilor and City Council President Tessa Murphy-Ramboletti, who also sits on Charter and Rules. And on Zoom, we are joined by Committee Member Councilor Linda Vacan. And in chambers, I want to thank those who have joined us. We have Councilor Devine, we also have Councilor Cascio and Councilor Jourdain. And on Zoom, we have our City Council Assistant and Solicitor Bissonette. Because we have a member on Zoom, I entertain a motion to take a roll call vote for the purposes of this meeting, which would be applicable to all motions to remove an item from the table, place items on the table, package items, open or close a public hearing, or suspend the rules unless there is an objection.
So moved.
All in favor?
Aye.
But I'm rusty on the Zoom rules. Do I have to actually do a roll call vote for this?
No.
Okay. All right. Let's begin. I'd entertain a motion to take item 1 off of
Motion
the
to
table.
take item 1 off the table.
Do I hear a second?
I didn't see the minutes. Did I miss them?
No, we're going to be motioning to table just because we haven't received them yet.
Oh, okay, then I guess we could just leave them on the table.
Oh, that's true.
True.
All right,
Whatever
so-
you want.
Sure. All right. So then we'll amend the motion.
Motion to lay item, or you can just keep item, you don't need to.
Just keep
Keep it
item
on the
1
table.
on the table. Okay. Do I hear a second?
Second.
All in favor?
Aye.
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 Oh, and I have to do a roll call vote. Linda Vacan,
Yes.
Murphy Ramboletti,
Yes.
McGrath-Smith, yes. Okay, motion to take item 2 off the table.
So moved.
Second.
All in favor?
Aye.
Aye.
This is item 2, filed February 4th, 2025 by Councilors Jourdain and Vacan. Ordered that the City Council adopt the following special act and then place the question on the November 2025 ballot. And I hope everyone has had a chance to review it. I had a conversation with our city clerk and also with our city solicitor, and I reviewed it. Of course, it's new to me, but I know it's not new to a lot of people who are in this room because it's something that from my understanding, after talking with Councilor Jane, has come up many times and has been passed before. So I'd like to turn it over. I don't know whether Councilor Vacan wants to speak first or Councilor Jourdain, but I'd love to hear just from the makers of the order around your thinking and what you're hoping will happen with this.
Well, Councilor Jourdain was the lead maker.
Okay, thank you. All right, Councilor Jourdain, would you like to give
Yeah.
us a brief and brilliant on this one?
Yeah, absolutely. So first of all, thank you for having this on the agenda. Basically, this is a rehash of an item that the council had adopted back in 2017. It essentially is word for word what the council had adopted at that time. This came about, as we all know, forever and a day, we always had 2-year terms for everybody. Then with the advent of the mayor going to a 4-year term, that was when this kind of resurfaced as an issue to say, okay, we've got now 3 4-year officials in particular. We have the clerk, the treasurer, and the mayor. Treasurer is now not relevant anymore, right, due to the decision that was made in January. So that one we can kind of take off the table. But as far as clerk and mayor now remaining, the decision was, well, how do citizens, if they feel that they've got somebody who takes off, is totally incompetent, is corrupt. I mean, you fill in the blank. Somebody goes MIA. Somebody says, "Well, I'm going to have a full-time job and I'll be the mayor or the clerk or whatever nights and weekends." I don't know. Whatever it is, but for whatever reason, the citizens are not pleased. This set up a pretty high bar, but what it would do is it would give, after a 2-year period, the public the opportunity to vote the person out if they collect amount of signatures. Now, I did have this hopefully everybody has received a copy of what the council voted for before. I don't know if you want me to go through that again or like kind of how that would all work. There would be a recall petition, there's a recall election. You know, the general view was not to do the 2-year officials on the basis that basically you're up every other year, and by the time you would go through the process, the person's term would be pretty much over anyways. So that was the view at that point. Wanted to, it's a bit of a golden oldie in that it is something, like I say, the council has addressed previously. The council's adopted it, the mayor hasn't signed off on it. I have no idea if Mayor Garcia would sign off on it. Different mayors have had different opinions about it. So I'm of the opinion that we should do it. Citizens have had a desire to have some sort of authority like this. Other communities do. But if the council doesn't want to do it, if the mayor doesn't want to do it, that's fine by me. But I did want to just resurface the issue this year.
Thank you. Does anyone else on the council want to speak? Yes, I see Councilor Devine.
Just a question, what happened in 2017?
Count.
On the ballot?
No, we didn't
Is her
need.
mic?
Oh, I'm sorry.
I see you, Councilor Bacon.
Yeah,
I'll call on you right after Devine.
No,
Yeah.
I didn't know if Patty's mic was on. I could hardly hear it.
Oh, sorry. Yes, it's now on.
What
Thank you.
happened in
2017.
2017, please?
Yeah, good question. Council passed it, mayor didn't sign it, so it
Which
died.
mayor? Just,
This would have been Mr. Morris.
okay,
So then it died. And because it would then need to go to the legislature and then the public would need to approve it. But it never got out of it, never left City Hall due to that.
so this particular thing now, the 4-year people.
Correct.
You want that to go on the ballot?
Eventually, yes, provided the council and the mayor support it and the legislature adopts it.
So it has to go to legislature first after the city council approves it?
City council, mayor, legislature, voters.
Oh, okay.
So there's 4 steps.
And all this
This would be
before
the home rule
November of
process?
2025?
Correct. Right.
Okay.
Yep,
And this would be the home rule process?
correct.
It could because it's a charter change
Charter
as well.
change. Yep, exactly.
So one of my questions, I reached out to our clerk because I just wanted to get a sense of what she thought the impact would be if we passed such a thing, and she said, "Well, it would be hard to know because we really don't see recall elections happen very often.
Right.
So it's not like there's a wealth of data to really understand in any way regionally what it would even look like."
Right.
And she said just some facts to share. Any election costs $20,000 to $30,000. So a thought around tempering what the threshold would be for the number of voters that would have to sign to want to do a recall, and balance that against how expensive an election can be. And one of the suggestions when I did my research was to balance it not based on a pure number, but based on a percentage. And you could do it based on a percentage of registered voters. So if we have 25,000 registered voters, then a 10% threshold would be 2,500 signatures, which could trigger then that election, which could be a great expense to the city. So just a thought around making sure that if we go forward the recall petition, in general, I'm in favor of any kind of democratic process that allows there to be extra levers for the public to pull when they need to, if there's really been an egregious act that they need to respond to. But I do worry about the fiscal responsibility side of it, if you know that's how expensive an election can be. If you get a group of citizens of 250 seems like a low bar. So I don't know if we would want to instead, if we move it forward, discuss a higher bar tied to it being registered voters or even actual voters. So, for example, if we did this actual voters of like the last state election, which gives us because it can fluctuate so wildly, as we know from our treasurer special election that we just had, where like state 2024, it was a 70% turnout. So if we did it based on the last state election and it happened this year, then that percentage would be 1,750 if you did 10% of the actual people who turned out to vote in the last state election. So that was just something to think about if we but again, to the will of the body, is this something that people are interested in pursuing? I think it could be interesting to pursue. But I think maybe we would want to temper it against a percentage that would protect the voters in case there was some sort of, a group of 250 people that just suddenly cost the city 20, 30,000 if there wasn't widespread support. It would need to be a high enough number that it really did speak of widespread support. Any other? I see Councilor Vacan's hand is up.
Thank you, Madam Chair. So I am comfortable with a high bar to prompt a recall election, but I share your view that there should be a process for the voters should an unusual circumstance arise. And I will share, just for purposes of our discussion, that we actually had a treasurer who did this, was elected to the position, took a private job full-time, and indicated that he was doing the full-time treasurer job for the city on evenings and weekends. Now, at that time, we had no provision for the public and the voters to take any action relative to this selected person. Fortunately, at the time, there was a will of the body to hold the person accountable, and it was handled through a financial approach. But nonetheless, we all serve at the pleasure of the voters, and it seems only fair that they should have a process and not leave it just to the 13 people in a situation such as that. So that would just be the only example I can share with you. Thank you.
Thank you. Is there anyone else who'd like to speak?
This is
Councilor
the first I've heard of this. Nobody ever complains to me that they want a recall petition, so I just want to mention that.
Councilor Jordan.
Yeah, not opposed to raising the signature, maybe make it 1,000 signatures. I mean, that's a pretty substantial. I think you need, 250 to be elected, the mayor, or I think clerk might be also 250, but to get on the ballot. But yeah, raise it up, 1,000. I mean, when we only had not even 5,000 people vote in the city election 2 years ago, it's pretty sad. I think the lowest all time in a city election, by the way, 4,900 and change. And, 1,000 is actually quite a few. We could even go 1,500. I think if you start going more than that, that might be a lot, because now you're thinking, well, if 5,000 people show up to vote, do you need enough signatures to actually have every person who would vote yes actually sign the petition to get it on the ballot, so that you're at a point where it's like to have it at 2,500 signatures seems like that might be a little bit high. But on the other hand, if you get 1,000 citizens or 1,500 maybe, to me, I'd be willing to completely compromise on that, on the theory that something's better than nothing. And it really should be a very high bar. It should be where, this is something that's outraging a lot of people and they want to be heard on it. And then hopefully either the situation is ameliorated and then the public official makes people feel comfortable, so then they don't vote them out, or on the other hand, there's a groundswell, and then they either resign, and hopefully we don't need an election at all. But yeah, this is something that should be extremely rare, and is only there as a worse sort of doomsday scenario. But otherwise, right now, under current law, what's the alternative? Whenever we're making decisions, we have to consider among our options, right? Yep. Well, the current law is somebody can do a lot of really bad stuff, negligent stuff, and they just say, you know what, I'm the mayor of Holyoke or the fill-in-the-blank position, but we'll use mayor as the obvious example, somebody we need to be here day to day, but now this person just goes MIA for, a year. I have to go find myself. I'm going on a year-long sabbatical. Well, there's really nothing you can do. You're now stuck with this person. What would you do in that situation? You have the public has no remedy in that situation. that's why I'm saying it's not great that we have to pass something like this, but the reason I wanted it to resurface is among the options, we have to have the public needs some option. So I'll leave it there, but your point's well taken about raising. I think the 250 could be much higher. Thank you.
Councilor Murphy-Ormaletti.
Thank you. So, yeah, I wouldn't be voting for this if it's 250. And I think I prefer a percentage rather than a number. I feel like that's the way that you have to do it with, if the citizens want a petition on on a ballot question, or that there's a very high threshold just for a question. So, I think, you could find 250 people who are upset about Walmart going in on Whiting Farms Road, and there you have it. And that's not as nearly as bad as getting in trouble with the law and then, not being present at meetings, and then, that's different. So I just think that there has to be a higher threshold. I would support it if it did. This isn't a super big priority for me, but I get why there's a need for it. I just think, it should, we know that it should be for the most dire of situations, but if someone gets fired up about a development project that the mayor might actually have no control over, or, stuff like that, I think it's just like a slippery slope. So I would just want to make sure that there's a higher threshold, because not only does it cost the city a lot of money, but it's there are times when a recall makes total sense, but there's times when it just doesn't make sense. So that's it. Thanks.
Councilor Durden, do you think it makes sense for us to table this order, or where do you see this order going?
Well, if people feel comfortable about the process, mindful of the fact that we're only one of 4 steps in the process, and that there's going to have to be a lot of consensus on this, I feel comfortable moving forward, provided, to your point, let's wrap our arms around the number that, if is it, 1,000 voters, is it 1,500 voters, is it 2,000 voters, correlate that into a percentage. 10% seems high if you're thinking all registered voters. I mean, that seems really, really high to me at 2,500. But
registered voters is 2,500. 10%.
What if we said 5%
based
at
on the
1,250?
actual voters of the last state election? This time, right, we had 70% turnout, so that reduces that by that 30% down to 1,750. That felt reasonable to me, and it felt like a benchmark that we could rely upon, because we've seen state elections have been more stable in terms of the percentage that we've seen. Mm-hmm. But I guess before we move forward, I would want to see, for example, what have the last 5 state election voter turnout numbers been, so that we really do know if it fluctuates or not. Mm-hmm. So maybe we just ask for more information from the clerk and table it, so that next time we bring it up, we can sort of set upon a number confident in the data that we're looking at.
Okay.
Because I only have 1 year of data. I don't feel confident enough that 10% wouldn't be radically different if it had been 2 years before that. So I'd like to see, I think, more of a data set.
Let's see here. Let's see. Recall shall be returned and filed within following the dates. The position is 10% of the total number registered to vote. Oh, okay. Hold on. I think we may account for this already. So let's read this first section if we could. Mm-hmm. It says 250 or more voters may file with the clerk an affidavit containing the name of the officer whose recall is sought, and a statement of the grounds upon which the petition is based, not less than 12 months prior to the expiration of the term. The names of the affidavit shall be from the city at large. The clerk shall deliver to said voters petition blanks demanding said recall. printed forms for which shall be kept available. The blanks will be completed by writing or typewriting. They shall be addressed to the city council. They shall contain the names of the persons who filed the affidavit and the grounds for recall as stated in the affidavit. They shall demand the election of a successor to office, and they shall be dated and signed by the clerk. A copy of the petition shall be kept on file in the office of the clerk in a record book maintained for that purpose. The recall petitions shall be returned and filed in the office of the clerk within 30 days from the date the petitions were issued, signed by at least 10% of the total number of persons registered to vote. So that is an important point. To get the initial affidavit to even start the issue, to even request, is 250 people, but you have to get 10% of the registered voters to act at the preceding who are registered to vote at the time of the preceding city election. So this does have your 10% rule in it. It's just, yeah, so there you go. Looks like you already already have it.
Great.
Yeah.
So I guess I'm comfortable moving this forward to council for a conversation there.
Does the 10%, does that make you feel more comfortable, Madam
And
President?
it's actually a higher bar than I was imagining. It's registered voters.
Yeah, sure. Sounds good.
Okay. I'll make a motion to move this to council with recommendation.
I'll second it.
Any discussion?
Just what's the recommendation again?
The recommendation is to, it's multiple steps, right? So the next step would be really getting the mayor's sense of it. The mayor needs to
Right.
sign off on it in order for it to even be considered for a home rule petition.
I guess I'm saying, is it 10% of the voters? Is it
10% of
2,000?
registered
10%.
voters.
And I think it's the 8th. We have Representative Duffy and Senator Vilas in DGR, so maybe we can talk to them about this as well.
Yeah,
Yeah, it's a good idea.
good idea. Yes.
The only thing that I was going to say, just it wouldn't make sense for us to have a whole lengthy discussion in a full council meeting if the mayor's definitely not on board. So part of me just, if it's possible to have, I don't know.
To table and ask for the mayor to respond,
I-
in writing or in person to the.
Yeah, I know that I'm not, I could pick up a phone and call him, but it sounds like we should be just having all public conversations. So if he wants to submit something, then that's fine too. Whatever you decide, it's fine.
I would just say that on that is, I'm not opposed to talking to him. If the council adopts it, and then it's coming his way, I don't have a problem. I would still want the council to vote, even if
Yeah.
he's opposed,
The council
because,
may even not approve it.
exactly.
So-
So if the council doesn't approve it, then,
Okay.
yeah, but I think it's a fair point that I will ask him to support it, obviously, if the council adopts it.
Councilor Bacon?
I'm all set. It was covered. Thank you.
Okay, thank you. Councilor Devine?
Yeah, so if I'm understanding, whatever this committee's going to do tonight, you're going to send it to the full council and have the full council discuss it,
Yes.
and you'll be there for 3 hours, just discussing that. Just to let you know, that is not going to be, in my opinion, that is not going to be something that's easy going to be do. And my feeling is, first time it's been brought up, keep it in the committee. I don't know, it just seems to me to bring it to a full council meeting for discussion, that's what the subcommittees are for. Just my opinion.
I don't, if I may, Madam Chair?
Sure.
I don't disagree. That's a great point. Problem is, I can't force people to come to these meetings. And, if they cared and wanted to discuss it, they would have been here. So either their schedules are busy or they couldn't make it, but we still have to do what we got to do here, and pretty much we could say that about every agenda item here, right? So I think the committee should, I'll talk to people,
Well, the motion stands. The motion is to move this to council with recommendation for adoption. It's been seconded,
Right.
and we have been under discussion. So unless there's more discussion, all right. We'll move to a vote. Counselor Bacon?
Yes.
Counselor McGrath-Smith? Yes. Counselor Murphy-Ramboletti?
Yes.
All right. Thank you. Okay. I entertain a motion to take up item 3.
So moved.
Second.
All in favor?
Aye.
This is item 3 from 3/4/25. This was an opinion from KP Law that was sent to us from our city solicitor. This was regarding voting requirements for fund transfers and special purpose stabilization fund transfers.
Could I make a friendly suggestion to the committee?
Sure.
If it's possible, you may want to consider taking up 3 through 9 as a package, because it's all basically essentially 3 issues. It's all these rule things. It's section 22, it's the special stabilization, and it's the year-end transfers. That's basically it in a nutshell. All 3 of those are discussions that myself, the council president, the law department, the mayor, different people have had on this topic, these 3 topics. And then there's going to be a lot of overlap in the conversations. So in terms of our discussion of it, just something, it's,
Why don't we take up items 3 and 4 are both about the end of year transfer procedure specifically?
okay.
So can we,
Yeah,
have a motion to take up item 3 and 4 together?
Motion to suspend the rules and take up items 3 and 4 as a package.
Second.
All in favor? Aye.
Aye.
And so that also adds then a second, this is from the DOR, the Department of Revenue, a guideline on appropriation transfers regarding alternative end-of-year transfer procedure. And so these two, my mic turned off. These two together, I think, form a picture around a conversation that's been happening in council around what happens with the end of year. Last year was the first time that we had gotten guidance from our city solicitor that the last 2 months of the fiscal year, the threshold for certain voting requirements was lowered and instead went to a majority instead of a 2/3 majority. And so going back and forth with them and also with members of council around, do we accept that interpretation or do we believe that our charter preempts it? I think is foundationally the question there. But I'd like to open it up for conversation for anyone who wants to weigh in. And I also want to name that Councilor Rivera and also Councilor Anderson Burgos, happy belated birthday, have joined us on Zoom.
Great.
Councilor Bacon, I want to recognize you. I see your hand.
Thank you, Madam Chairman. I would just like to note that in that guidance from the DOR, it indicates that the year-end transfers may be adopted by a majority vote. It's not a matter where they are stipulating that it shall be changed. So I think that's an important distinction that I haven't really heard discussed in the opinions. Thank you.
Thank you. Is there anyone else who would like to speak on this topic?
I would if I may.
Yes, Councilor Rudin.
Okay. So on the year-end transfer issue, the first thing I would point out is a couple issues. One is we have the general rule from section 49 of the charter, which says that any appropriation from one purpose to another requires a 2/3 vote of the city council. That's section 49 of the Ohio City Charter. This has been the rule from time immemorial. What this 2017 law change stated was that you had these other option. It said that the council may make a transfer, not that it shall, but it may, and have it by majority vote in the last 2 months of the year, plus 2 weeks technically, because there is a closeout period in the first 2 weeks of July. So essentially, there is this option to change on year-end transfers. However, it's important to note that the DOR makes clear there is no issue of preemption. This issue is surfacing on our table because there's been the suggestion that Section 49 of the Holyoke City Charter is being preempted by the amendment from 2017 to Chapter 44, Section 33B, which said, and let's just remember what the old law was. The old law said these are always 2/3. Then they said that you may now, in this change, may in the last 2 months, and effectively 2 months, 2 weeks, have it that it would be only by a majority vote. So, therein lies the question is our charter preempted? From 2017 to current, there had been no view that this was the case, but this did recently come up because apparently we had a situation where there was a year-end transfer desired. There was a lot of discussion. I discussed this with DOR legal counsel as well, and I was also pointed to the actual DOR guidelines that were issued at the time that this law change came out. And I would draw the council's attention to Section 3, which states governing law. It says, and by the way, this is just, every time one of these substantive law things come out, the DOR issues guidelines for the cities and towns so that they understand what the law change is. It says, the procedures explained in these guidelines govern appropriation transfers unless a charter or special act provides otherwise. Okay, so our Section 49 is otherwise. It says that it's 2/3 all year long. Now, those two things were easy to read with the old 33B law because they were always said the same thing. But when they passed the 2017 amendment to allow the option, again, key word, and the law department has opined on the words, the difference between may and shall, right? And may indicates, if this was preemption, just so we're all crystal clear on what that means that the state is saying, clear the deck. You cannot do something other than what we tell you to do. And if it was preemption, they wouldn't say you may do it. They would say you shall do it, okay? So, and then simultaneously, they're giving out this guidance that says, if you have something to the contrary, you follow that. DOR legal counsel told me this is not an issue of preemption. The issue is if you interpret these things to be appropriation transfers, then follow your charter, okay? At the other hand, they'll also tell you at the end of every time you have these discussions with them, we don't get involved in this stuff. I'll just tell you what,
It's a local decision.
It's a local decision, exactly.
Yeah.
So what I'm suggesting is there is no preemption. This is, in my opinion, when you read the word may, not shall, and two, you read this guidance, which says that your local charter, and which we have a special act charter, governs, I think it's crystal clear that our Section 49 governs here. And this issue is not, there is no change. Our section, we took an oath to uphold Section 49, and it says it's 2/3 vote.
Would anyone else like to speak on this topic? Yes, Councilor Murphy-Romaletti.
I've said this before, if the council wants to pass a rule or something that clarifies the end of the year transfers, it's fine. I mean, I guess, we have a legal opinion from an outside law firm. And while I am usually more inclined to, go with if there's an outside legal opinion that we've requested, but I personally don't feel too strong one way or the other about the end of the year question. So it's just where I stand for what it's worth.
So in this document that we have from KP Law, so I've read the DOR guidance, I have reread section 49 of the charter, and I agree that it says unless underneath governing law, and I agree that it says in section 49 that it said it's a 2/3 vote. And then in the KP Law brief, it says, in my opinion, the specific provisions as recently amended, will govern the quantum of vote for action by the City Council, notwithstanding the more general provisions of Section 49 of the City Charter. I therefore concur with your department's prior opinions, which are consistent with the rules of statutory construction, and allow the provisions of the City Charter and relevant statutes to be applied in a harmonious manner to achieve the intent of those provisions. To determine otherwise would, in my opinion, be contrary to the purpose of the more recent and specific statutory enactments. So, again, I'm not a lawyer by trade, but I will say, swimming in all of this, we have different opinions that are being surfaced. That's sort of like the battle of the lawyers around like, well, I believe it means this, and I believe it means that. We have a city solicitor that says, I believe that this was statutorily created in order to respond to very real city needs. And so, yes, we should, in effect, follow the state guidance. We have an outside law opinion that also concurs with that. So if we choose as council to say, no, we're going with the charter, it is against the recommendation of our legal counsel and the outside opinion that we have. I just want to name that for the public record to understand why counselors are confused on this issue, because it really is these dueling interpretations of, do we go with state statute or do we go with what our charter says?
Madam Chair?
Yes, I see your hand. Councilor Bacon.
Thank you. Thank you. So I believe the question before us is, do we want to change our charter? Because we've all taken an oath to uphold the charter, which we have consistently read in one way for years, up until this year. Now, if our charter is our governing document, which I think we've all agreed that it is, and if the guidance from DOR says you do this except if you have something else, then to me, if we want to change how we're doing what we're doing, then we have to amend our charter. Up until then, I believe we all took an oath to uphold it, and it clearly says a 2/3 vote. Thank you.
Thank you. I just want to read one last section into the record. This says, this section of the charter, it's referring to section 49, which I'm informed has remained essentially unchanged since the charter's enactment in 1896, addresses transfers from appropriations generally, but does not address either fund transfers undertaken at the end or beginning of a fiscal year, or the creation of appropriation to or expenditure of funds from a stabilization fund. These omissions are not surprising given the time of enactment of the charter. The charter has been amended over the years to address certain items, such as the change in the form of government from a board of aldermen to a city council, but the provisions of section 49, including the superseded reference to the beginning of the city's financial year, have remained intact. In my opinion, this section of the charter continues to apply generally to the process of the city council in consideration of fund transfers and appropriations. However, in my further opinion, this provision should be read in harmony with later statutory enactments that more specifically address such matters, and the quantum of vote requirements of applicable statutes should be applied by the city council. It sort of goes back to an argument of enumerated powers. Are we talking about the charter is the charter and a universal document that is the be-all, end-all? Or is it a document that is not naming all things? And so if it's not named in the document, state statute can then apply, which I think is what this outside opinion is arguing. Again, taking in the information, trying to understand these dueling arguments. I see Councilor Rivera's hand, and then Councilor Bacon, and then Councilor Jordan.
Thank you, Madam Chair. So, real quick, just for clarification, we have an outside opinion that states one thing, and then we have the city solicitor's office that states something similar to the outside opinion. And then what's the other opinion that we have?
An alternate reading based on the explicit and specific language of the charter.
Interpreted by whom, though? By a counselor?
I think it's part
I
of
think that's where the
it's
confusion
a
lies.
wider conversation. I think Councilor Jordan is speaking for that part, and he I think is nodding in council chambers. I'm not trying to call him out, but I do think that several councilors I think are here naming that.
Okay, thank you. I think for me, it was just having an understanding of where it's coming from, because there's the piece of like we had an opinion from one office, the solicitor's office, then we went in further and tried to get a third party. We got that as well, and then for me, it's like I don't know, there's professions and everybody has their professions. It's a respect to everyone else, but like certain people are getting paid for certain tasks. And not to say that they can't be wrong, because they can be, but it's not to say that we can't be wrong either. But thank you.
Yes, thank you. I see Councilor Vagan, Councilor Devine, and Councilor Jordan.
Thank you, Madam Chair. I guess I would just like to make the point that it's also a matter of past practice and the continued understanding and agreement unanimously of the body in terms of interpretations from 2017 right up until this whole debate began, I want to say, within the last year. And it seems that it's a desire to get things done in a different way because they're not able to be accomplished under the long-standing interpretations and understanding that the council has held relative to our charter and relative to state law. So that is of concern from my perspective, because I don't see as a general matter that there has been any problem with following our charter on other debated issues over time, certainly, that have happened. But we haven't needed to throw away the language of Section 49 or Section 22 of the charter to accomplish any of our other prior decisions. Thank you.
Thank you. Councilor Devine?
Yeah, thank you. I'm not sure if you have this, it says 10 up there, city council voting specifics, okay? And to me, this seems like it covers everything. It's almost like a Bible. And I know you were talking about the transfers within the last 2 months of any fiscal year, and it says majority of city council present and voting. And then it gives you the section 40, or Mass General Law, section 44, section 33B. So this is what I'm going to follow when I have questions, and I believe this was from the law department.
Yes, thank you. Councilor Murphy-Marletti, and then Councilor Jordan.
Okay. Well, we're going to at some point have a discussion on the voting specifics ones, because that is not 100% agreed to either. But let's just back up. If we want to go on to the history of all this, this is undisputed the way things have always been. No one from 2017 up until the last, I don't know, 6 months, 9 months. So apparently from 2017 until 2024, that 7-year period post this law, has never suggested this. I will say, if we go, one of the things I'm concerned about the KP law opinions generally is I don't care for the current practice relative to third-party independent legal opinions, air quotes, because I am not given access to these attorneys to then have them. If that was going to, for me to give weight to that, I give it very little weight, okay? But if I were to give weight to it, it should be, okay, let me listen to everything you have to say, and then let me listen to everything you have to say, and I will make an independent opinion. That's the way it should work, but we don't have that. That is requested by the law department to a vendor of theirs, okay? And then basically what they say is, I agree with the law department, all right? And they don't ever address in this opinion the obvious points I'm making.
Enough.
Enough of what?
I'm going to ask that we
is
not
there a problem?
speak unless unless called upon, please. Councilor Jordan.
Thank you. So they do not, I make a number of obvious arguments here. None of these are addressed in the opinion, such as, do they address the point that the DOR, this is the Department of Revenue, they oversee this entire statute, okay? They have complete regulatory authority over this. Not the Hoyle Law Department, not Kevin Jordan, not Rin Tin Tin, okay? Nobody, them. They have their own guidance, says your charter governs. So why is that not addressed in the KP law opinion? All right. Number two, the statute says may. Preemption is a huge hurdle. I would, again, I'm trying not to go too heavy on the legalese here, but there's cases from when the Home Rule Act was adopted in the 1960s to where we are today, a long lineage of cases. You have to show and this is from the Bloom case all the way through, that basically there is no way that the local law can be read in a compatible way with the state law. It is completely legally incompatible, and there is no way these two can be read harmoniously. So that's the high bar. The bar isn't, 50-50. It's 99-1, okay? And that means that if someone is now going to advance an argument that the city charter doesn't govern, they have to advocate that there is no possible way these two things can be read harmoniously, and that it's in a sphere of law that completely forecloses other arguments. Well, this one's the obvious one. The statute itself says it isn't even compelling. It doesn't say you shall. They don't address that in the argument in the KP law opinion. It says may. Why would the legislature, if this was their intent to create preemption, these are smart people. They have legal counsel in the legislature. They write these laws, okay? If they wanted to preempt this and say, no, all 351 cities and towns are going to do this, they would not say you may do it. They would say you shall do it, okay? Point number two is, there's about 99 communities right off the top that don't have special act charters. They actually have charters under Chapter 44. Chapter. So if you go to the Chapter 40 exemption, Section 20, it right there tells you if there's any conflict between your charter and any of our laws, your charter governs. So the DOR, if you call them up, they'll tell you right off the top, all of those are automatically not preempted. So now you have a statute that says may. You have an opinion from the DOR legal guidance that says follow your charter if there's a conflict. And you have an exemption hole the size of Worcester in it. And yet we're going to say, oh no, this is all preempted. Don't follow your charter anymore. We're going to say, you follow this for the end. It doesn't even make sense. I will say for coming attractions, there is a stronger argument to be made for preemption on special stabilization funds, okay? Because that has a different rubric, all right? We'll get to that in a moment, I'm sure. And I will concede points on that one. This one, slam dunk, no brainer. This is not preemption. It's not even close to preemption, and we should follow our charter. But to the point that was made earlier, I would have no problem if we take Section 49, just like we did with Section 22. We adopted it and put it into our rules. This one, to me, it's not even a close call. And if we want to change the charter, change the charter. But you can't just say on some opinion, I'm going to just, by my virtue of my opinion, I'm just going to start amending the charter and say for the last 2 months of the year, Section 49 doesn't apply, and follow the legal case law on this. So that's my point. And as far as KP Law goes, a very reputable firm, no question about that. But I do not feel, under the current practice of these independent opinions, I do take exception with the fact that I am not allowed to call them. I'm not allowed to follow up on their opinions. And this is not just this year, it's previously, and have these questions answered. So I have a hard time putting much weight into those opinions because they need to address the salient arguments that I'm making. Thank you.
Thank you. Murphy Rombletti?
Thank you. So I'm honestly, like I said, I would be fine with doing a rule, but I really have to address the comments around not having access to KP Law because we met on, what was it, January 21st in the mayor's office. It was Councilor Jordan, myself, the mayor, representatives from the law department. And from that meeting, it came out that we were going to ask KP Law for a legal opinion. And so I guess in that meeting, I'm just feeling kind of frustrated that in that meeting, this didn't come up, that you needed to have direct access to KP Law and tell them all of the things that you wanted them to review in the legal opinion. I didn't speak with KP Law myself. That's not my job. I don't need to. I could, but honestly, I do a lot. I go above and beyond as president, and I feel like I don't need to do that. That is why we have outside counsel. So, I think I'm frustrated at that narrative and that somehow, folks are trying to keep you from communicating with KP Law, because I've actually set up meetings with you and KP Law about other items. I've coordinated those things. I have gone out of my way to try and have some kind of a happy medium here. But for, that if that's going to be the practice for every legal opinion that a specific counselor has to talk to them about every legal opinion, then why are we even spending the money on it? Because, it's a waste of their time. They're lawyers, and you said it correctly. They are the most reputable municipal law firm in the state of Massachusetts. So I it's fine if you don't trust the law department, or if you don't, whatever it is, whatever the issues are with the law department. I'm so beyond that at this point. But I can't keep picking at straws when I'm truly trying to get the information to everyone that is requested for an outside party legal opinion. I don't think that at KP Law they're trying to conspire with anyone. I think they're literally just taking a look at the facts. Again, I don't even have such a high stake in this matter, but at the same time, to hear that, past practice, past practice, past practice. And last night, at our full city council meeting, for past practice about late files, I have seen counselors write during a meeting a late file, and they hand it to the clerk, or they hand it to me, whatever. I've seen that. So if we're going to talk about past practice, I mean, I'm exhausted from hearing when things in past practice are fine, and when it's just like I'm going against an oath that I took to the city of Holyoke. I mean, it's exhausting, and we can do, honestly, correct me if I'm wrong, there's nothing actually before us to vote on for 3 and 4. So if folks do want to file something, that's cool. Like, I'm fine with that. But I never know when past practice is going to apply and when it's not. And the last thing I will say is that the state issues these kinds of guidelines because they know that many cities' charters are old and not as relevant. I mean, there's things in the sections that we're referring to that say when the fiscal year starts, and they say some really old things that we haven't changed. They're still in our charter. So I guess that's it. Thanks.
I think the motion that I'm hearing is just to receive for 3 and 4. And I'm not sure if there's further conversation. I do know that there's many other things that need to be addressed in the meeting, so I'm wondering if we can bring this to a close and move to. Okay, I'm seeing Councilor Devine. Yes.
Yeah, I completely agree with President Murphy Ramboletti. I believe, if I'm not mistaken, that Attorney Ball had somebody in here from KP Law in a meeting. And I know they sat right there, so certainly we've had the opportunity to speak to these people. And to me, there comes a point where you either, look at the law department, of which they are extremely qualified, or you just say, well, I don't agree with them, so since I'm a lawyer, you have to agree with me. No disrespect. So that's my take on it.
Councilor Bacon?
First, I would like to offer a motion that we receive item 3 and 4.
Second.
And that's it. Thank
All
you.
in favor?
Aye.
Aye.
Aye. That hopefully brings us to a close.
Almost. If I may, I'd just like to point out a couple things.
Thank you.
Because I want to be fair.
Could you do it in 1 minute or less? I'm just looking at
Absolutely.
time. I really want to move
No,
to
no,
the
I
next
appreciate
conversation.
that, but this issue prevalent to these other ones, because KP is referenced here elsewhere. Couple points. One is, KP Law came to us on cannabis. That was the issue that they came in, extremely available, okay? I personally had a conversation with legal counsel and came to the meeting, answered all our questions. Perfect. Let that be the model for these rules issues. For some reason, the prior KP Law opinion of 2 years ago, I specifically asked questions and I was not allowed to speak to them. And furthermore, or at least I sent an email, I got rebuffed. I didn't get an answer back, and for whatever reason. Point 2 is, if we were going to use them, then I would have liked to have an opportunity to have my say with them. I'm paying for their salary. I pay taxes, a lot of them, by the way, in this city, okay? And I would like to have had an answer, make my points. This way, I just feel heard. I feel like I'm standing up, in my opinion, for the institution, the 100 years plus that we've been doing this, and this charter. I feel, for me, this is upholding my oath. This is me standing up, Kevin, for the charter and exactly what it says, okay? And I think the weight of the arguments here is overwhelming on this year-end transfer issue, like not even close. We'll get into the other ones, but if I would ask if we're going to do anything more with KP, that if counselors, and I appreciate the president, I think she is trying to do the right thing here, is to make it them available that we can ask questions, that when they write an opinion, we can have questions after their opinion, and that they will speak to us. Okay? That should be the ground rule. So enough said on that. Thank you.
Okay, thank you. I would like to entertain a motion to take up as a package 5, 6, 7, 8, 9, and 10.
So moved.
Second.
All in favor?
Aye.
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 Oh, you know what? I think on 3 and 4, if we're receiving, do we still have to do a roll call vote? I don't think I did one.
No, you're okay.
Okay, all right, just double checking on the Zoom requirements here. Okay, so these are all grouped together because they all largely address this issue of first readings, second readings, and what the requirements are. Item 5 is from the city solicitor, Lisa Ball, the case of Fuller v. Haynes. We have item 6 from City Councilor Kevin Jourdain, an email communication to the city clerk and city auditor regarding irregularities of financial transfer votes at the February 18th meeting. We have item 7 from City Councilor Kevin Jourdain, an email communication with the auditor regarding discussion with DLS to address the financial 18th financial transfer vote. Item 8 from President Tessa Murphy-Ramboletti, an email communication with Councilor Jourdain regarding first, second readings for financial transfers. Item 9 from Councilor Kevin Jourdain, response to email communication from President Tessa Murphy-Ramboletti regarding first and second readings. And then item 10, this is Jourdain and Vacan, ordered that the City Council Charter and Rules Committee discuss the Council's long history of interpretation relative to Section 22 of the Charter, that a vote to pass the first and then a vote to pass the second reading are required before final passage may occur under the provisions of that section. But the Council also continue to follow our current procedure if and until the Council votes to change that procedure and understanding of Section 22 through a lawful method to be determined up to and including a possible charter change. And then all of Section 22 of the Charter is then named in that document there. I do want to, this of course is a very interesting section of our Charter that begins with laying out streets and ends in describing how we vote for our ordinances. And I just want to read the relevant section there, which is halfway down, which says, any ordinance, order, resolution, or vote involving the appropriation or expenditure of money to an amount which may exceed $200 shall require for its passage the affirmative votes of a majority of all the members of City Council. Every such ordinance, order, resolution, or vote shall be read twice, with an interval of at least 3 days between the two readings, before being finally passed, and the vote at its final passage shall be taken by roll call. Provided, however, that upon and after the written recommendation of the mayor, the City Council may pass such ordinance, order, resolution, or vote on the same day by a 2/3 yea or nay vote, or yea and nay vote. Okay, under discussion, I think we could go in a wide range, but I think the goal here is just for us to be able to discuss the history of this and also the current interpretations of first read versus second read, so that we have an understanding of our common interpretation of this as a body moving forward. Under discussion? Yes, Councilor Vacan.
Thank you, Madam Chair. So I'm not going to get into any discussion about all of the details of the communications back and forth, but what I would like to address is the context as from my perspective. It seems like because through regular order, a certain order did not pass, that subsequent to that, there have been these novel interpretations of things that have never been questioned before, seeming to be aimed at getting the desired result. And that is my main concern. If we were simply having a debate that was not in the context of something that had failed to pass on 2 or 3 occasions, then I would see it as a philosophical and interpretive situation. But this seems more like a way to achieve an end. And that is probably for me the most problematic aspect of it. And I'm not a lawyer, as most of us aren't, but I did read the very old lawsuit, so I guess things that are old aren't always without some value. But when I read that old case, it said since the body didn't have a rule relative to the first reading, that they called it the first reading. But we clearly have a rule. It's right in writing that you just read into the record tonight. So I appreciate you listening to my perspective on this matter. Thank you.
Thank you. Councilor Murphy-Ramboletti and then Councilor Jordan.
Thank you. So I think the thing I just wanted to address is that, oh my God, I just lost my train of thought. My brain is mush. Can you come back to me?
Absolutely.
No problem.
It's gone.
Happens to the best of us.
Yep.
Do
All right,
wanna go when we come back, or?
Right, you go.
Okay, Councilor Jordan.
Okay, no problem.
And then we'll come back.
So just to kind of, again, for the public who's trying to, or anybody who is bored this evening and would like to understand.
Hey, this is high drama.
Exactly,
This stuff is
yes.
fascinating.
This is good stuff. So if you like, how the sausage is made type of intrigue, we have this provision of our charter, which the long-held interpretation of this is that we have to pass the item as the chair read. You have to have a vote to pass the first reading, and you have a vote to pass the second reading. Mind you, by the way, we have the same rule relative to ordinances. And if you look in our rules, we'll have a vote to pass the first reading and a vote to pass the second reading, and then we'll have a vote that the passage be ordained. There used to be 2 other steps, by the way, before that on enrollment and all this. That's actually the reduced version, which we changed a number of years ago. But we do have that. So in this same spirit, we have this this charter provision that says that you'll have 2 votes, that the vote is to pass the first reading and then the vote to pass the second reading. And if the 2 readings occur 3 or less days from each other, okay, then the vote at final passage is 2/3 vote. But if it's more than 3 days apart from the 2 votes, then it's a majority vote, okay? Where somehow along of recent note, this thing went off the rails a little bit, or we're having an internal misunderstanding somehow, is that it creeped along that there wasn't actually 2 votes needed. There's been a suggestion that the first reading just means it shows up, it appears, it comes on the agenda, and that there's actually not 2 votes. There's only 1 vote, and that's at the second reading. And what I'm suggesting to you is that's not the case. So I'm suggesting to you that this is the long-held view that there's 2 votes, okay? And I think that's what Section 22 is saying. This is the way it's always been interpreted. We don't have a preemption issue here because there is no state law on this point. As far as, I'll leave what Linda Vacan said relative to the Fuller case, because I think that addresses the Fuller case. The Fuller case says in that fact pattern, there wasn't a special rule. Here we have a special rule. This rule, Section 22, requires 2 votes, and I think it nails it, that the vote at its final passage be by a 2/3 vote if those are within the same 3-day period. Okay. If folks are really interested in this, having majority votes for the second vote, simply vote because we're all in agreement. You know, if we want to move forward, we're all in agreement that you can't do both on the same night, right? So timing wise, we're good. But the only thing that I'm suggesting to folks is if you want to have a vote on the second reading, you bring it in and pass the first reading. Now, these things come in, and before they go to the committee, we send it to the committee, because if you weren't to do that, you're putting the council in an awkward position that you're actually passing the first reading before you've even read it, before it's even had a committee hearing. This is why the council's never done that, because councilors didn't feel comfortable voting to pass the first reading when they've never had any discussion on the item. So normally the historical perspective on these transfers or any of these items that come in is it's put on the agenda, it goes to committee. Committee has whatever they're going to do, they have their discussion, they report it out. Then we make a motion to pass the first reading, always a majority vote. Second reading is a 2/3 vote. So there you have it. This rule, I think, does speak that, for its passage, the affirmative votes of a majority of all the members of the council. The only other thing that recently creeped into this that I would like to address is there's a suggestion in the voting specific things that was referenced earlier by Councilor Devine. I want to take exception with this new interpretation. And this will be throughout that voting specifics, which says, Chapter 44, Section 6, there's a reference that in the a statement that it says, when the council that she's relying on the state default rule that says when it is not articulated what the council vote, it's a majority of those present and voting, okay? Or at least present. But I addressed that in this email, that in fact is not the case, because when you go to section, that particular section, and read in the header of the definition section, it says crystal clear, unless the legislative body has manifested intent otherwise. Then it reads, you've got to put that clause in because we have manifested an intent otherwise. Go ahead.
I just wanted to pause you to name that item is technically laid on the table.
Okay.
And we definitely, I think, should come back to that.
Okay.
But I didn't put it on the agenda tonight because I didn't think it would come up in the context of
Section 22.
Section 22.
But that's being used in 22,
but
just so you're
I just want
aware.
to name for open
Sure.
meeting law that I didn't put. It's technically laid on the table.
Okay.
The chart that you're referring to.
Okay, so I'll try not to get too much into it, but I will just simply say that a couple things. One is this council at Rule 1 says that these are votes of the whole body, and that any vote, and then if it requires a 2/3 vote, it's a 2/3 vote of the entire membership. That's the most obvious intent of the body, right? We actually have a rule on this topic. The other thing is these transfers are occurring as a result of Chapter 44 of the state statute. And I would commend everyone to read Section 1 in the definition section. The legislature for these transfers has already articulated what a majority vote and a 2/3 vote constitute. And it says right in there, as applied to cities, the vote taken by a yea and nay of a majority or of a 2/3, okay, as the case may require, of all the members of each branch of the city government where there are 2 branches, or of all the members where there is a single branch of the city government. That's the state law. So we should follow state law. I mentioned 1A, so I won't go over that again. That says of the entire membership. And yeah, I think that captures the issue. I think this could be easily resolved if I think the only difference of opinion here at this point is a vote on first reading and a vote on second reading. You need a vote on first reading. It isn't just reading it or it appearing on an agenda. That is not what Section 22 requires. That's not what Section 22 has ever required. We've been doing this for 100 years this way. And let me just say, this isn't just, well, we've always done it this way. You know, that is not it. And I just want people to appreciate, there has been a lot of really smart people, including now, that have been through the law department who have read this. There has been a lot of really good counselors that have come through this room. Okay. And I will tell you that I have talked to Counselors McGivern and McGee, and I think it's fair to say we don't all agree on substantive issues, but on this interpretation that I'm espousing to you, we're in agreement on this point. And this is the way this council operated under Joe, Todd, myself. And again, no slight on the current president. I don't mean that in any reference. I'm only saying is that these things have had a consistent interpretation for many, many, many years. And I would appreciate if we would get back to regular order on this and take the two votes on both readings. And the way you could achieve it, because I get there's the political dynamic of the 7-6. And I know, you know, there's people that want to spend money and don't want to spend money. But the way to do it is either we're taking a vote on first reading when the item first comes in, or when it comes out as a committee report, vote on first reading, and if you think you don't have the 2/3, table it and wait 2 weeks and then pass it, and then you only need a majority so that those two votes are occurring more than 3 days apart, and you're good on Section 22. Might be if it's a transfer, then you got Section 49 to deal with, but you know, but sometimes these things come in and they're not really a transfer. For example, we have an intra-departmental transfer, right? Those were there. Those don't require a 2/3 vote. The only reason those required a 2/3 vote, which by the way is the subject of my email, is because the two readings occurred on the same night. And oh, by the way, on this meeting, they did have the two. Go back into the minutes, we actually took both votes on both readings the same night. It's in the minutes. And then on the tape. And so that's why I don't think that item validly passed, because it lacked 2/3 of all the members of the council for all the reasons I stated. But so I've spoken enough. Thank you.
Thank you. Has it come back?
Yeah, it came.
Councilor Marumbaleti, and thank you, Councilor Rivera. I see your hand as well. You can go next.
I guess I won't take up as much time. I disagree. And I think that's just what it comes down to. I disagree that about the rule, there being a rule that so explicitly talks about the first reading. I'm reading it right now, and it says, again, every such ordinance, order, resolution, or vote shall be read twice with an interval of at least 3 days between the two readings before finally being passed. I mean, I read the night of the meeting. I read it into the record. We vote to send it to committee, or we vote to lay it on the table. And I also have spoken with Councilor McGee and former councilors McGee and McGivern, and you know they've acknowledged that they didn't realize there was case law on this, which the case law that hasn't really come up, but there is case law on this, and I've seen when it has happened in past meetings where, I've spent a lot of time going through past meetings, so I'm happy to send it to the committee where the language was different than what may have been said during this term, but it has happened where that was the first reading and it got laid on the table. So maybe laid on the table wasn't said and whatever, but I mean, I just, I guess, sometimes we just won't agree on whether or not there's an actual what the rule is reading, because I see it very clearly that it just says it shall be read twice with an interval of at least 3 days, and that happens. So, and just for what it's worth, I've heard a lot about how this is happening as a result of not getting what folks want, or where it's an end to the means, and I see that with everyone. Saw it last night. So, for what it's worth, I just, once again, I'm not sure when we are supposed to follow certain things and when we don't. So I guess there you go. Thanks.
Councilor Rivera.
Thank you. I think for me, where I stand, and I think if we could suspend the rules to ask the city solicitor, what is the definition of a first reading? And what the rules state for the definition of a first reading. Because if it doesn't clearly define that, I think for me, I'm trying to understand where the first reading lies. If when we first file the order and it's read the first day, is that not considered a first reading? The city solicitor, Mr. Knight, if possible.
Yes, Councilor Bissonnette.
Thank you, Madam Chair. Councilor Rivera, that's a good question because it has not been defined. Just as if you look in your rules or in the charter, if you look in the charter, as opposed to your rules, there's no requirement to send any of these orders, ordinances, financial transfers to a committee. It just requires that the council have it under consideration for at least 3 days between votes. After first reading, I would refer you to your own rules, which says that the president shall read all orders. And so that would possibly constitute the first reading in a literal sense. But if you look at the opinion, it seems to require for a first reading to have some action taken. So my interpretation is the first reading would include a vote to either send to committee or to lay upon the table. That would mean the matter has been on an agenda, it's been read by the chair, it's been considered and either laid on the table or referred to a committee. That does nothing to impinge on the number of votes needed for a second reading or a third reading to be enrolled and ordained. So I think what you're arguing about is when does that first reading happen? And I don't know, perhaps Councilor Bacon and Councilor Jourdain may have a recollection of an argument.
Well, I'm only asking you because if I have a feeling that if I ask, I would get a certain answer in a certain perspective, and I need an unbiased perspective in this moment right now to help fill me in, because it's been some time that I've been getting filled in on certain things, and now I feel like I don't know where I stand on certain situations as a counselor, and that's my own fault for relying on some of my colleagues and some of their suggestions on certain situations. So for me, moving forward, I'm going to have to heavily rely on the city solicitor's office to make sure that I'm not getting unbiased information and making sure that the information that's being put forward is information that is true and binding, right? And I say this because not to say that anyone is not speaking truth. I think for me, the reality is that if we don't have a true definition of what the first reading is, how are we saying that another reading is a first and a second or a third reading technically? So just because it's been done that way for so many years doesn't necessarily mean that it's right. Again, I think for me, I'm trying to understand logistically the legalities and how things are being run. And if we're going to go by the rules, then the rules should literally define what is a reading then, if that's the case. And if people want to go back and define that, make sure that they can outline it so that it matches the historical context that they speak of, then they can file an order and do that. That makes sense, right? But I think for now, the way it's being interpreted, it's leaving it open for someone to either understand that first reading is when the president reads it as a first reading, or it could be a third reading after they do it's voted out of committee, and then it's passed first reading, I shouldn't say pass the first reading anymore, I should say pass the second reading, and then pass the third reading, and then passage be ordained, because technically it's a third reading when I'm doing it, and I'm reading out my committee minutes. But again, thank you, City Solicitor Bissonnette, for your explanation.
It's helpful, thank you.
I will say that I have been trying to go back into Robert's rules and understand first read versus second read. And of course, Robert's rules doesn't address it in as such. But I did do research. Thank you, Councilor Devine, for joining us. I know it's getting late. It does speak to previous notice. And it seems that the spirit of what is in Robert's rules is that it wants there to be notice made to the public and notice made to the people in the room who are going to be voting on an issue, that they've considered it before they are voting for it. And there's clarity that it's coming for consideration and potential passage, whether it is that night or after an interval of a certain amount of time. And I completely understand they're wanting to be a different threshold. If something is taken up, and we do this all the time with specifically with the injured on duty transfers, where, and we don't really do this with anything else, right? But in that particular case, it is so time pressing and it is so routine, right? There's information that is shared. We know what to expect. We know it's coming. It's given to us in a very specific form. There's often no questions to be asked about it, or that even can be asked because of confidentiality laws. And so here we are, we're gonna pass this tonight and we're gonna take final action. And so yes, there needs to be a different threshold in order to do that. I understand why on the same night you would wanna have a higher vote threshold. But I do think that the way the charter is written, there is real space for interpretation. I'm a writing teacher and social studies teacher by trade. And I will say, you pour over these documents and man, like if they were in my class, I'd be like, let's clean that up. This is confusing. You have not made it clear what the subject of your sentence is. Do we need to have 5 clauses here with a subject that is completely divorced from the action of the sentence? That makes it totally possible to be interpreted multiple ways. And in this case, like I looked at Councilor Jourdain, his argument that was in the email to the clerk and the auditor, item 6, around how he was, looking at the concept of affirmative votes and what that phrase meant. But I was considering affirmative votes of a majority of all members, votes from members being a complete subject. Then I interpret it differently because I'm looking at it as if it has a different clause structure than somebody else who's reading it. So when I read it, and I've read this now many times trying to be like, what am I missing? Because I have people on council who are like, lockstep, there's no way to interpret it any other way. This is what it means. But when I read it, it looks to me like it says that we need to take it up, do a first reading. I don't see it defined what that means. I think it makes sense. We're passing it, we read it out loud, we pass it to committee, and it's discussed. It's been read. It's been discussed, it's been considered. Previous notice has been given and it's been considered. And then it has to get voted out of committee. And then the council has to vote to take it up. Like a lot of votes have happened. Right? To like Councilor Rivera was like, it's almost like 5 or 6 votes, really, to take an item up, to vote to send it to committee, for the committee to vote to take it off their table, to discuss it and consider it in committee, to vote to send it back to council, for council to vote to take it back up. A lot of consideration and previous notice has happened. That under Robert's rules looks a whole lot like previous notice, looks a whole lot like consideration. So that's where I'm struggling, because when I read it, I do interpret it like it does. And again, it's like a goldfish in water, right? I'm new to council and I'm in it. I'm just going to do what I see everyone else around me doing, right? A whole lot of how we do rules is based on precedent, whether we want to admit it or not. Because we're also just like, as we're coming into council, and all of us came into council new at some point, we were doing what we saw other people do. And this has been the precedent for a long time. But I actually don't see that this language locks in that precedent. Ordinance, we have very specific language in our own rules. So there, right, for, is that 8K, 5K? What is that? 8. Okay, so section 8 under voting. K says every ordinance shall be considered as adopted by final action of the council only after passing the following 3 votes. And then it names them very clearly. And we don't have that for anything beyond an ordinance in our rules. And section 22, I believe, is murky at best in terms of specifically saying this is the one interpretation you could follow. I can see other interpretations. And I think that what the city solicitor has said around readings, it makes sense to me. Again, it might just be because I'm new here and I'm not as in the water as other councilors have been. But when I look at Robert's rules and don't see a very specific procedure that it says we have to follow around first and second reading, it certainly does seem like we're doing it before it's coming back to council and then we're taking it up again. It's already been taken up somewhere else. So, Councilor Bacon?
Thank you, Madam Chair. The point that I wanted to make is that the second half of the sentence of section 22 was read, but the first half says a vote involving the appropriation or expenditure of money to an amount which may exceed $200 shall require for its passage the affirmative votes of a majority of all the members of the city council. The fact that the order is read into the record is not a vote unless we actually vote on moving the money. At the time that the order is read, we then take that action. If we don't do that, we have not taken an affirmative vote, and this clearly says we need to do that. And then it gives us the opportunity, by having it read twice, the first reading and the second reading, that if it is the will of the body, with a 2/3 vote, we can pass it in the same night. So I think the language clearly calls for the votes. I mean, that is clear, whether you can debate when you take the vote or where you want to send it. Generally, the president of the council has wanted things to go to committee so that we don't spend a long time debating them in chambers. So, but that is a matter of choice of the council relative to any order. But the language is clear on requiring 2 votes. Thank you.
Thank you. Councilor Ruding?
Yeah, thank you. I would like to, because I think it's important, since what the section says, and I'm glad Councilor Bacon went there because I think it addresses the points. It says, shall require for its passage the affirmative votes of a majority of all the members of the council. The word votes is plural, not 1 vote, 2 votes, right? 2 or more. But then it goes on to say, by the way, what that sentence is meaning, you have 2 votes and they're by majority. That's what that's saying. But then they put a clause, they modify it. And here's where it says, every such ordinance, order, resolution, or vote shall be read twice. So now it's telling you not 1 vote, 2 votes. With an interval of at least 3 days between the 2 readings before being finally passed. That word finally is an important word. Not just passed, but finally passed. Okay? Passed the first time, passed the second time. Next sentence. And the vote at its final passage. Final's an important word there because there's multiple passages. Otherwise, the word final would not be required in that sentence. There'd only be 1 passage, the passage at second reading. Final passage. Shall be taken by a roll call. And oh, by the way, that's exactly what we do. First vote at first reading is a voice vote. The second reading is always by roll call vote, because this section requires that. Provided, however, that upon or after the written recommendation of the mayor, the council may pass such an ordinance, order, or resolution, or vote on the same day by 2/3 yea or nay. So what it's saying is, as long as these two votes have an interval of 3 or more days, then it's majority. And the last sentence is, if you do it less than that, the second one is a 2/3. But the only thing I think in dispute, I think we're all in agreement on the 3-day interval. I think we're all in agreement there's a vote at the second passage. Somehow we're off the tracks on the first vote, that there's a vote to pass the first reading, and that there's two votes, the passage of the affirmative votes, okay, 2 votes. And so what I'm suggesting to you is, as long as we have the passage at first reading and passage at second reading, we're good. Send it to committee, don't send it to committee. All I'm asking for is the council maintain. And so as far as what we're all learning, I am in the same unenviable shoes you were 30 years ago. I had to learn this, and I would ask. So how you're feeling about all this is totally natural and totally normal. I was in your shoes. So this stuff is not intuitive. You have to really get into the weeds and work with it. And then you say, well, why does it, that? I've had those same conversations in the 90s when I got here. So all I'm saying is, this was explained to me by law department, by counselors, and they had been doing it for 100 years before I got here. And this has always been the way it's been. And what I'm trying to suggest is, on the case law point, I'm trying to make the point that Fuller doesn't apply as of just a reading, because this is the rule that the Fuller decision says. If you have a rule, you follow that. But in the absence of that 1916 case, yeah, then we would go to that, right? Just showing up is a reading. I don't deny that, okay? I would agree with that, of what that holding is. But they put a big caveat right in the middle of that sentence, in the key sentence in that holding. And it says, but if you have a rule, and that's what section 22. Our founding leaders, they created this. And that's what we should follow. That's what we've always followed. And by the way, that's a 100-year-old case. I don't think a law department for 100 years and all the controversial stuff that have come through here would have missed that for 100 years. Thank you.
Thank you. Councilor Rivera, and then Councilor Murphy-Ormaletti.
Yeah, thank you. I think for me, again, it's just hard for me. Doesn't matter how long, who, what, where, when, why, historical context, all the other stuff. If you read the language and what it says, and there is no definition clearly as to what first reading means, it's open to interpretation. So right now, what it's sounding like is that we have some counselors that want all the counselors to continue carrying on the interpretation that they were once told about, whereas other counselors want to follow another interpretation that they're being told about from their city solicitors and their other colleagues and people they're working with. So like, it's not that it's a different situation. People are learning from each other. As one counselor mentioned, they once learned from a city solicitor back then and their counselors, right? And it's the same here. I think with the understanding of what the language is breaking down, it's easy just to write a rule and clarify that language with the first reading. If not, if it's left the same, then it's open to interpretation for all of us to interpret it as we want. And as a council, we have to literally define that. What is the first reading? What is the second reading? What is the third reading? Just because it's crazy that like a couple counselors can just literally influence everything based on how they feel. And it's a body of 13, right? I don't know. I think that it would make more sense if there was an actual clarification stating out what we are saying around the first reading. If there isn't, then I don't understand what the issue is, other than the fact that people have been doing it historically one way, but it's not wrong to do it this way either. It's just not the norm, which is fine. We're in a society today where a lot of things are not the norm. That's okay, as long as democracy is still having its due process. Again, we can agree to disagree and move on and try to have the city move on so that we can be productive as a council and as a body. This term, I have to admit, I feel like we have not been as productive as any other terms in the past. And I've only been on 2 terms, but I just say, speaking just in general. And it's difficult to be productive or get things done within the community when people are just like literally pulling strings or pulling hairs to prevent due process. But again, due process is interpreted to each and every individual as to what they see it fit, because that is democracy. But I think for me, I just have to hone down on the fact that if we're talking about rules and we're talking about language and interpretation, then the language doesn't necessarily dictate what is first reading for us to be able to say this is first, this is second, and this is third. Thank you.
Thank you. Councillor Murphy-Romaletti?
Thank you, Madam Chair. Super brief. Every time I hear the argument that this is what our founders wanted, I have to say it for the record. The city was founded before I would have been allowed to vote. The city was founded before Councilor Rivera would have been allowed to vote. And the city was founded before I would have been allowed to be president. So I can't, I just, for what it's worth, I have to say it into the record that we weren't there when the city was founded. We weren't there when the founders were writing all these things up, so we can't speak for them. But what I do know is that it's a very different world, and that's just needed to say it for the record. Thank you.
Thank you.
In terms of where we go from here,
I think the motion here is to receive all of these items. And I want to thank everyone for, I think, a really productive conversation. I feel like I'm back in my senior constitutional law class. And I think that it makes sense to receive these. And I think if folks want to follow up with companion orders and consider either charter changes or rule changes, I think that's up to the different individuals on council who may want to then do something about this. But I still think it was a really productive conversation. I want to thank everyone who was here to have it. But I do think it makes sense for us to move on at this point if possible.
in terms of suggestions,
see-
Madam Chair?
Jeffrey's hand up.
Oh, okay.
Jeffrey, I see your hand.
Yeah, just have Nicole.
If you're speaking, Jeffrey, we're just not
In,
hearing
in
you.
the past, motion made in a committee. Can you not hear me?
Now we
You're
can.
breaking up.
It's just a little echoey.
Yep, the signal in here is really bad. My question is, sometimes you've made a motion to receive and let items remain archived in the committee, whereas other times motions to receive have been made and you still wanted to report them out. I'm just wondering, looking for clarification on your motions to receive the items.
I believe it makes sense for us to receive them and still report out on them in council, as it will take different orders and different action in order to do anything different with what we have. Does that make sense, Jeffrey?
He's muted.
You're muted, Jeffrey.
I think he may be coming to the.
Yeah, sorry, it's just my signal keeps
Oh, sorry.
interrupting me. That makes
All right, Councilor Bacon?
Thank you, Madam Chair. I'd like to make a motion that we receive item 5 through item 9.
Okay.
Second.
Any further discussion?
Could I just say as a takeaway? So I heard a lot of good points were made about maybe we need to put something in a rule. I mean, we have section 22 in the rules, right? But we don't have, well, and this means this, or if there's some people are trying to perhaps get to a definition or get to a clarity. I'm I'm happy to take a shot at drafting something for a future council meeting to send the charter and rules to, if that is helpful. Because I think that's what I was hearing from Councilor Rivera, perhaps from the president, was that maybe we need to have, if this is what we want to do, we have more clarity. If to use what I think I was taking away. So
I'm
will-
hearing from Councilor Bacon, who made a motion to receive 5 through 9, that the goal, I'm guessing, Councilor Bacon, is that next you would want to lay item 10 on the table?
Correct. Thank
Okay.
you.
All right, so I hear a motion to to receive items 5 through 9 and to lay item 10 on the table?
Can I just get a clarification, Madam Chair?
Yes, absolutely.
So, based on Jeffrey's question, these are going to be referred back to full council?
So this is one of my questions and items that are received. Effectively, we've received them. It's done. So in that case, where do they go? Do they just disappear? Or,
Madam Chair.
yeah.
So my thought, because there's nothing in these items that asked us to recommend an action to the council.
Yep.
So to me, if we're receiving them, we've discussed them, and I then think the best thing to do would be to archive them.
Okay. Okay. Yeah, I mean, if that's the goal, I'm more than happy to do so. Another option is marking them as just complied with. Okay, so,
Yeah, too, if you prefer, I can amend my motion. I'm happy to do whatever the majority wishes in that regard.
yeah, all right, well, let's amend the motion to make them items 5 through 9 complied with.
Second.
So moved.
All in favor?
Aye.
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 And then item 10 to lay on the table?
Yes, please.
Madam Chair.
That's my motion.
10 is the action item, but now we need, since I
So we're
filed
tabling
it. Right, we table it, and I'll come back with a suggestion, and then the committee will do what it wishes with it. Okay, thank you.
Okay, and all in favor of tabling?
Aye.
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 All right, can we take a 1-minute recess? Oh, no,
Sure.
Sure.
thank you. Let's take a
Exactly 1 minute?
Yes.
Okay, I'll time it.
Don't you dare go to the bathroom before me, Councilor Rooney. Okay, I'd like to call us out of recess. All right, I think it makes sense, the will of the committee, but since we did complied with for items 5 through 9, I think it would make sense for us to actually go back and do the same thing with 3 and 4.
I'll make a motion to reconsider our action on 3 and 4.
Thank you.
So moved.
All in favor? Aye. Can we can I entertain a motion for us to mark 3 and 4 as complied with?
So moved.
So moved.
Oh, second. Sorry. Thanks.
You could not have
Take
done it
your
on
pick.
purpose. All of the above. Okay, all in favor? Aye.
Aye.
Okay. All right, let's
I'd
take
like
up
to make a
item 11
motion
and
that we
12.
take up 11 and 12 as a package.
Perfect, yes.
So moved.
Okay.
I mean, second, sorry.
All in favor?
Aye.
Aye.
All right, so 11 is from City Councilor Linda Bacon, an open meeting law complaint regarding debate of late files. And then item 12 is from Assistant City Solicitor Kathleen Degnan, a response to that open meeting law complaint from Councilor Linda Bacon regarding debate of the late files. Councilor Bacon, do you want to begin by outlining the open meeting law complaint that you had filed?
Sure. I don't know if you want me, okay, so what I will share is that I referenced the orders that had been filed and noted that action had been taken on them when they had been filed approximately 2 hours before the meeting. So my argument is that they didn't meet the definition of an emergency and they didn't meet the definition of unexpected because these had been hotly debated and contested items in city council. Legal opinion had been requested. The legal opinion was provided on January 31st, and the chair of finance filed the orders following the advice in the legal opinion. So my position is that the legal opinion was provided in enough time for us to have had those orders back before us in regular order on the agenda, and that there was not a justifiable reason for them to be filed late. So then Attorney Degnan gives her response to my complaint, and in it she says, and I'm not going to read the whole thing, but she says, in the first place, there was no violation of the open meeting law. And then she follows that up immediately by saying, if there was a violation of the open meeting law, said violation was cured. And she argues that because it was left on the table and no action was taken, that then it was proper notice to act on it at the next meeting. And however, we then go to the next meeting where she then claims that the first reading happened at that meeting, which is an action. So both things cannot be true at the same time. And my hope is that we could view the 18th as the first proper notice of those orders being timely filed and cure the problem by sending those orders to finance, which is what we had done in the past. And it just seemed like the whole process got changed because it didn't pass. And so now we're changing how we're doing our votes and how we're doing our readings. And I just don't think we're following the law. And so that is the reason why I filed this. And I would just like us to be in compliance. I mean, we don't, any of us always get our way on votes. I am much more often outvoted than I prevail with my vote. So it's not like I'm accustomed to prevailing. However, I do think that when the will of the body is expressed, we shouldn't change our interpretations and our procedures and how we're filing and dealing with things because of that. Thank you.
Thank you. Yeah, so one of the things that I know has come up a number of times, and Councilor Bartley had 2 orders on this agenda, which I think I'm tempted to leave tabled because he wasn't able to attend tonight. I would like to hear his thoughts on as the maker of the order. But I do think that late files in general is something that I'm very interested in Turner Rules bringing up. I was going back over the rules. My Lord, it is a long section. You can tell based on how long the rule is, how problematic late files has been forever. Because you keep seeing people are trying to get it right. You know, you have the base rule and then it was amended and then amended again and then amended again and then amended again. And Councilor Bartley has put forward 2 other possible amendments to it. So I can tell just from the document itself, there's that little trail of history there saying we haven't always gotten late files right and it's been tricky. And I understand that because we want to allow enough, room for something to really be addressed if it needs to be addressed, and also to give respect or deference to counselors that we want to give the benefit of the doubt if they're putting in something as a late file. But also, you can see in the rules consistently, man, stop filing these late orders that aren't actually emergencies. Please follow the actual rule that says that it should be by 12 or by 11 o'clock, depending on the day, or 1 o'clock. So I do hear that late files has been an issue consistently, and I know that even last night it came up as a conversation around agendas. It's really frustrating when the mailed agenda is not matching what happens. And I walk into every council meeting and I've put notes on my agenda, and then I immediately realize that it's actually not the most updated agenda, and I have to go get a new agenda, and then like be looking at both documents all meeting long, looking at my notes from one and transferring it to different numbers on the other. So I don't know if this needs to be just handled in late files, or if it's sort of a wider question and we should maybe, invite in the clerk or ask Jeffrey to kind of have more of an active voice in it. Or if this is something we're going to sort of just hash out sort of one-on-one between ourselves and the clerk and Jeffrey. But it does strike me that we have to find a way for the agenda that's being sent out to really be the agenda that we're using. And I do think there's questions around late files and how we get that information afterwards. I do think that part of the question is, when is the agenda really locked and mailed? And then, late files being added after that, and how we get access to the documents related to late files, which largely right now are coming in over email. That's fine for me because I'm an email native, right? I'm gonna check my email constantly. That's not true of everyone on council. And some folks maybe aren't getting late files or aren't finding out about them until they get to council for the meeting.
So,
Councilor-
Madam Chair, I'd be happy to file an order potentially to look at our rule relative to late files, but in terms of the specific agenda item that we're on, the cure to the complaint that I'm seeking is to take that order that was deemed passed on February 18th, that is the only controversial financial transfer we've ever called passed that never had a first vote, and put it back in what we usually do and send it to Finance Committee and have it go through the proper routine process that we use for all of our financial transfers, i.e. last night, every financial transfer, package X number to X number and send it to finance. And I tried to make that motion that night. I tried to say to the body, we're not following the open meeting law, and the majority would not, send it to committee. And so that is the cure that I propose to the problem. Otherwise, I don't see it cured. Thank you.
Thank you. Do you want to speak on this topic? Councilor Murphy-Ramaletti?
Sure do. Thank you. Just a couple things on the January 21st, 2025 meeting. Councilor Sullivan filed a late file for a transfer request for the demo supervisor. If you all remember, there was about a 60-minute discussion, and we did try to vote on it. It didn't pass. It got sent to committee. I have to believe that actually, I don't really know. If that had passed, would an open meeting law complaint be filed against Councilor Sullivan? I'm actually not sure. So I feel like it's really important to note that, I'm not sure, honestly. At that time, there wasn't, while folks weren't thrilled about trying to vote on it that night, and myself included, it shouldn't be it should be the exception and not the rule. As much as we weren't excited about doing that, there was no accusation of open meeting law complaint. So or open meeting law violation. So I just feel like it's important to note that for the record, that, this is not something that I'm doing for the first time ever, like that other counselors haven't done. If you ask me, I say we get rid of the whole rule altogether that late files are allowed at all, because if we can't enforce it, also, it seems like it should be up to the president to decide whether or not something is worthy of that. And I do know that there have been times where counselors have been told, not by myself, but either by the clerk or by our administrative assistant, that they're too late. Which is fine. If it's going to be them to do it, that's fine. Cool. I get it. But even last night, the late file, I didn't want to vote on that last night, and that seemed to really ruffle feathers that there was a late file, because the reason why I was doing that is because we need a superintendent or a director of the DPW, and we know all how long these things can take. So for me, the urgency was, and I did try to outline that in the order. It's also, the rule itself is not clear where that language should be, if it's supposed to be presented inside the order itself, or if it's supposed to be emailed to the president. Is it supposed to be, it just says that, it written form. That's not very clear. So yes, I agree with the chair that this whole rule needs either a lot of work or just get rid of it. But then we had a late file last night. It was a communication that Councilor Bartley submitted. I don't know why that was urgent. I'm glad it was submitted. That's fine. It wasn't controversial, but again, it comes down to the president. And if we have a divided council and people don't agree with what the president does, then there's really no way for me to enforce it. In general, I don't even like the rule. If you don't get to the 1 o'clock, then it is what it is. You're done. That's unfortunate, but pay attention to when the deadline is, I guess. I mean, I'm guilty of it too, so I don't know, but I guess I just, once again, wish there was some consistency. Thank you.
Thank you. I do want to name from the open meeting law response from Degnan, that she wrote that the February 4th, 2025 meeting to which Ms. Aiken refers did not contain a listing of those orders, although they were listed on the City of Holyoke website where they were fully described. See a copy of the agenda for the meeting, a copy of which is attached here too and marked as Exhibit B. I do think that something can be not best practice. I don't think it's not, maybe it's allowable, doesn't mean it's great, doesn't mean we should be doing it. And I think that late files coming in and not making it onto a printed agenda that counselors have, but it's on the website, is a very low bar that I would like to see us respond to in terms of how we restructure the late file rules, because I don't ever go to the Springfield, to the Holyoke City Council website in order to see the agenda. I'm looking at the document that's been emailed to me, or the document that's then has been mailed to me or printed for me by the assistant. And so similarly to what Councilor Murphy-Ormaletti is saying, last night I didn't feel great having to vote on an order that I didn't have on an agenda anywhere, and that I didn't feel I had the documents to even fully understand what we were voting on. So
The one that got referred to committee? I'm just trying to clarify.
Yeah.
But we didn't vote on it.
Well, we voted to send it to committee.
Okay, I'm just trying to clarify.
Yes.
Okay.
But didn't feel great that I like information. I want to be able to see the thing that I'm voting on, whether it's like an official vote or if we're sending it to committee. So I do think that it sounds like from the law department, they believe that it's been cured. I think it's a very low bar to say it's on the city website, and I think that we need to relook at the late file rules in order to address that, so that can't happen again. I don't think that should be the bar at which we're setting. Technically it's on an agenda somewhere, but I do think that it should be on an agenda that we have access to, either by email or printed. And maybe we also, you'll notice later on in the meeting, there's an order to look at just the way that we structure meetings. Maybe also there needs to be something in our agenda somewhere where earlier in the meeting, we're reviewing like which late files are on and making sure everyone's on the same page around those if they do exist. Yes, Councilor Jordan?
Yeah, just a couple points. One, I think the issue with yesterday for me was right on point with what you just said, Madam Chair, was the fact that apparently, I think I learned afterwards, it was actually put on the website at about 9 o'clock at night. So about 2 hours after the meeting had actually begun. So, again, I know some people don't like all these historical contexts, but way back yonder, before the kind of the stricter rule on late files, which we all collectively need to do a better job on these and making sure these are an emergency, is it used to even be far worse in the good old days, okay, that the council was bringing in a lot of stuff. And basically, in around or about 2016, one of the reforms under the former Jourdain regime at the time was that we took a look at this, and the law department said, you really got to be careful with this late file stuff, because the state law, at the end of the day, trumps our rules. And just because we allow it doesn't mean OML allows it. And number two is anything reasonably expected to be on the agenda has to be on the agenda. It has to be the, oh my God, something has happened that no one could have reasonably expected this. It's a true emergency. That's the threshold bar for coming in last minute, okay? And that's why that rule sort of took on this genre of emergency. So I guess, when the reason I took exception to the item last night was, like, we even have late file stuff coming in on Monday. We have stuff coming in on Tuesday. But Jeff, at least when I go to, because the agenda most of the time is not accurate, the one I actually get in the mail on Saturday at my house, because there's always a few items added to it, and the numbers don't add up. So I make it a point at the beginning of the meeting to go up. Thankfully, Jeff does a good job of putting these extra copies. I go by that. And even on that one, which is literally at 7 o'clock, there was an item that came in that I didn't even, like, what are we even doing? So that was the only reason on that. No way, no how should it be represented that that's the only time that that's ever happened, and absolutely. The other thing I would say to be careful is, one, all these things should be really true emergencies if they're coming in. I've gotten away from late file stuff. I used to be, way back when, more of because we're all super busy, but I think most of the late file stuff is coming in from departments more than even counselors, okay? And they really need to, that's a real rule. Like this, the Monday at noon is a real rule, and they should follow it, because it's almost like, well, if we get to, I know everyone's busy, but we'll get to it on Monday, we'll get to it on Tuesday, and send it around. I would encourage them not to do that. The third thing is, slightly back to the Section 22 question again. Got to be careful now, because what you're basically seeing here is two interpretations now of something that is going to catch people on an OML violation, in my opinion. For example, you look at this transfer. These things start coming in late file. Table, right? One breath, we have people saying, no, that's for the next meeting now. This is where you get trapped. Mm-hmm. Tabled, we didn't do anything with it for OML violation purposes. But no, on the other hand, you're saying, no, we did take action. We did the first reading. Can't have it both ways, guys. So you're walking yourself right in my opinion, by in one breath saying, I'm taking final action because we're constituting the first reading. And then in the next breath, you're saying we didn't do anything with it, because otherwise to take action on the item means you violated OML, because those items had been debated for a long time, and yet we're coming in reasonably expected. That item should have been on the regular agenda. So there's this, can't have it both ways in terms of what we're telling the AG's office for OML and what we're actually doing too. So we just have to be careful. Of course, I'm of the opinion that if we do the 2 votes, then you've got your defense that we didn't take final action and we just tabled it and put it onto the next agenda. But if we're constituting that as a final action on first reading, you got to be careful. So thank you.
Thank you. I think that okay, I see Councilor Bacon's hand. Do you have a motion?
Yes.
Or another comment?
Well, I have I want to put out a request for consideration to the committee because my proposal to cure the issue is that this committee recommends to the council that we send that transfer order to finance at our next city council meeting. And if this committee would recommend that back to council, then I would feel that it cures the open meeting law violation. But that's up to you two.
I don't know if I feel comfortable doing that, especially because we do have the opinion of our solicitor that says that if there was a violation, it was cured. But also, secondly, because I'm not sure what the ramifications would be. The ramification would be of sending it back now when it may already be in motion. If people have already received pay based on this, I don't know how we could reconsider it without having real legal ramifications for the city from the union.
I don't know that we know what has happened with it yet. I don't know what the auditor has done with it.
Solicitor Bissonnette, are you able to provide any clarity on that?
Suggest that the committee and the council would wait the decision from the state concerning the councilor's complaint. Law Department has made its response on behalf of the council, and we'll await that decision.
Okay. All right, so that sounds to me instead that it makes sense at this time to table, waiting for the state's response.
Well, the committee will have, if the complaint continues on the path that it's on, it will continue through the AG's office, and then the AG's office will make the decision. What I'm proposing to this committee is that if this committee is willing to put that transfer into Finance Committee, as we have done with every other single transfer of regular order, then I would consider the complaint closed and I would not pursue it further with the Attorney General's office. That is what I'm sharing with the committee tonight for your consideration.
Since the full council voted on this, I'm not sure it exists anywhere where we could do that. I'm not even sure there's a mechanism to allow that. Councilor,
So the full council, so the full council sent the open meeting law complaint to this committee. And the complaint says what it says. And in an open meeting law complaint, you are required to put down your proposed cure for the complaint, which I have done. So the city council sent it to this committee to act on the open meeting law complaint. Now, if the committee chooses to table it, then I will have to follow the open meeting law rules and continue on the process. But the city council didn't have to send it anywhere. The city council could simply have received it. I would get the response. I might try to respond again, or I might not. and send it up to the AG's office. The reason why I was okay with it coming to committee, I was hoping maybe we could cure it.
Thank you.
But if it's the will of the committee, if the committee feels they do not want to recommend that action to council, I'll accept that decision.
Thank you. Councilor Murphy-Ramboletti?
Thank you. I don't feel comfortable recommending that this evening. I won't recommend that this evening. And if Councilor Bacon wants to send it to the Attorney General's office, she is well within her right to do so. I also, if something has been voted on, and you can only reconsider that night. So I mean, I'm happy to table it. The state hasn't even responded, so it doesn't really seem like it makes sense. But yeah, whatever the body wants. I just know how I'll vote, so thanks.
Well, I would feel comfortable with us tabling this or marking it as complied with. Councilor Bacon, what's your will on this motion?
Well,
This order?
I personally think these things shouldn't be sent to committee. I don't see
Okay.
particularly the point of it, but I guess you could call it complied with in that it was reviewed in committee and no action was recommended from the committee.
Alternatively, could receive it. I mean, whatever.
Well, we have been doing complied with.
That's totally fine.
So
Yep.
So I'll entertain a motion that it is complied with.
So moved.
I'll second.
Okay, any further discussion? All in favor? Aye.
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 Okay, so that was on item 13 and 14. Item 15
That
was
was-
an
That
erroneous.
was 11 and 12.
Oh, I'm so sorry. Yes, sorry. That was 11 and 12. And then items 13, 14, and 15.
No.
Sorry,
no.
give me 1 second.
Just 13, please. I'll make a motion, take item 13 off the table.
Okay.
Do you want to say what you were going to say? Were you going to talk?
No, I just wanted to name that coming up. We have item 15, which is an erroneous agenda item that shouldn't have been added to the agenda. So just so folks know that we're not going to be taking that off the table tonight. It shouldn't be on the agenda.
Okay.
Because it was something that we voted on last night.
Okay. So which one? Sorry, Councilor Bacon, what was your motion?
To take up item 13.
To take up item 13 off the table?
Second.
All in favor?
Aye.
Aye.
All right. Under discussion?
If I may?
Yes.
So item 13 is from the Office of the Attorney General, a response to an open meeting law complaints. These are complaints that were filed by a citizen and myself. And what I would simply like the chair to read the conclusion into the record because the whole document is quite lengthy.
Absolutely. So this is an open meeting law complaint that was filed on March 5th, 2025, between Stephen Superba and City Councilor Linda Bacon against the City Council. The conclusion was, for the reasons stated above, we find that the council violated the open meeting law by failing to identify the litigation matters to be discussed in executive session on June 11th. Additionally, we find that the council violated the law by failing to declare prior to convening an executive session that holding the discussions in open session may have a detrimental effect on the council's litigating position. Finally, we find that the council violated the law by discussing matters in executive session that were not appropriate for executive session and were not included on the notice for the June 11th meeting. We order the council's immediate and future compliance with the open meeting law and caution that future similar violations may be considered evidence of an intent to violate the law. Additionally, we order the council to announce at its next open session meeting the specific litigation matters or types of matters discussed in executive session on June 11th. Oh, my copy looks cut off. I'm so sorry. It says
You want
finally.
me to read? I can read the rest of it
If
if you
you
want.
can you read the rest from finally?
Yes. Finally,
apologies.
no problem. Finally, we order the council to release the minutes of the June 11 executive session to the public within 30 days of the date of this letter. We note that the council may reject portions of the minutes if the attorney-client privilege or one or more of the exemptions to the public records law applies. However, the council may not redact any portion of the minutes that record the discussions of topics that were not appropriate for executive session and were not included on the notice. See General Law, Chapter 30A, Section 22, and then it references District Attorney for Plymouth District, and it makes some other versus Board of Selectmen of Middleborough, 395 Mass 629, 634 in 1985, explaining that the open meeting law constitutes a statutory public waiver of any possible privilege of the public client in meetings of governmental bodies, except in the narrow circumstances stated in the statute. Now, I would note that this letter was sent to the city on March 5th, and it was not sent to council until the 18th. So I think those minutes need to be released probably by tomorrow. And this is not a committee decision. This is the Attorney General's office giving a finding and an order to release. So I know we have an attorney on the line with us tonight, and I'm sure he'll make sure that this is accomplished. I'm confident in Attorney Bissonnette doing that. Thank you.
Solicitor Bissonnette, do you want to weigh in on the cure request here, or demand rather?
Well, that's going to be handled by Attorney Degnan tomorrow, I imagine.
Thank you. And it also sounded like we have an upcoming executive session planned in order to do a litigation update. And I know that there's been care taken to make sure that we are following in the spirit of the law as we're moving into having executive session minutes listed on our agendas now, and also making sure that we are absolutely following it to the T as we make sure that we create agendas that give enough information to the public that they would understand with a reasonable amount of knowledge what we're going to be discussing and why it's an executive session rather than open meeting.
And Madam Chair, if I may.
Yes.
I hope that there will be a review of those tabled executive minutes for release in the executive session, because now it's been 6 months since there's been a review for release. Thank you.
That's the goal. Yep.
Okay. Yes. Councilor Rumboletti reports that is the case for the executive session meeting coming up.
Great. Thank you.
Okay. Should we have a motion for this to be complied with?
Motion to take up item 14.
Do we want to vote on this being complied with first, or?
Oh, yeah.
Oh, 13. I'm sorry.
That's all right.
I'll make a motion that it's complied with.
Second.
All those in favor?
Aye.
Aye.
Okay, motion to take up item 14.
Second.
This is from Murphy Rumboletti, letter regarding municipal finance reform update. All in favor?
Aye.
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 Okay, Councilor
Motion
Murphy.
to receive.
Yep.
I thought we weren't discussing. I thought we weren't.
Was it 14 was sent at the previous meeting? I believe the issue was that 15 was just put on, I think.
I'm sorry. I'm so confused. And honestly, my brain doesn't work great at 9 o'clock at night, so we got a lot left on this agenda. I'm just letting you know. 14
under discussion, or do we just want to move to the motion to receive?
Yeah, motion to receive.
Okay. So Councilor Vacan made a motion to receive. Do I have a second?
Second.
Under discussion? Hearing none. All in favor? Aye.
Aye.
Okay, again, 15, we're not taking off the table tonight. And we're going to move to 16 and 17. I think it makes sense for us. I'd entertain a motion for us to table.
I'll make a
both.
motion to leave them on the table.
Second.
Thank you. Just to read them into the record, in an abbreviated way. 16 is from Bartley. City Council Rule 4 is hereby amended as follows. Add the following sentence to the end of the first paragraph of Rule 4B. So long as it is in writing to the clerk, any member may opt out of having his or her agenda sent via U.S. mail and instead may have the agenda sent via electronic mail, personal delivery by the administrative assistant, or not at all. Said decision shall remain in force until the clerk is otherwise notified in writing by the member. That is to effectively ask us to consider revising a rule that we revised last time because he caught something. But again, I need him to be here to be able to walk us through exactly the intent there and make sure that we're discussing it in the way that he wants us to address it. And then 17 by Bartley is a suggestion for how we could revise City Council Rule 4 around late files. So I think both of those we can hopefully put on an upcoming meeting agenda. I definitely want to get to both of these soon. Okay, so the motion is 7 tabled, and there was a second. All in favor?
Aye.
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 Okay, 18. Jeffrey, could you put up the link that I sent you and go to page 2?
Just one moment. I had to switch computers that I was using for Zoom, so I've just got to get that document open again.
Sure, no worries. So again, the motion, if I could entertain a motion, take up item 18.
So move.
All in favor? Aye. Item 18, McGrath-Smith ordered that Rule 1C be revised to align with modern practices. So currently, I went through all of the rules and just started to find a number of places where I wanted to get clarity or I wanted to make sure that it actually is stating what we're doing. And I kept finding things going, we're not doing that. And I believe that there should be clarity on rules because rules are how it's the norms and ways that an entire body operates. And I want to make sure that what we have on paper is what we're actually doing. So currently, it says all rules and orders of the city council shall be read by the president of the council to every newly elected city council during the first meeting of that newly elected council or at any time prior to said first meeting if the city council so agrees. So I will speak for myself that when my first city council meeting happened, I was given the rules. And in fact, I had been emailed them beforehand. By the clerk who'd been kind and been like, sure, here they are. So that you could start reading them over and like understanding them and asking questions of, your folks who have been reaching out to you, like Counselor, McGivern, or Counselor Tallman, who are lovely gentlemen who were great at answering questions early on when I was trying to understand what I'd gotten myself into. But no one stood at the podium and like read them, right? They're long, they're complicated, right? They're shared. So I'm wondering if it makes sense instead to shift to a new rule that simply says all rules and orders of the city council shall be distributed by the president of the council to every newly elected city council during the first meeting of that newly elected council or any time prior to said meeting if requested. I also wonder why we say all rules and orders and not just the rules. I would like clarity on that phrase even. So just under discussion, I would like to hear what folks think about changing that and if that proposed language makes sense. And if someone could please tell me what we mean by all rules and orders. Because the first meeting is an organizational meeting. There are no orders. Yes, Councilor Jordan.
If you actually look to the header on the rules, the formal title of our rules is the Rules and Orders of the Holyoke City Council. So it's referring to that document.
That's so random.
That's what that's always been called.
Does it
So
make sense to call this document the Rules and Orders?
I guess the view is that a rule is an order of the body.
And we just want to add rules and orders and norms and procedures. Like we could have many words there to describe it. It just seems so random.
Yeah, but the point of that rule is, that the president and historically how it's always been done is, would do orientations with the new members and would sit down. In the old days, pre-computer, you'd get the large black book that's then turned into a green book, which is now no book. And the black book would be given to each counselor. You'd have your name embossed on it, and then you would be given a set of the rules, and then it would be multiple sessions would sit with you, usually about 2 or 3, where they would go basically from rule 1, and of course this is pre when 2 years ago we had at one time 66 rules, and all the rules were numbered. They're reorganized in the manner Councilor Maldonado Velez contributed to the form that we have today. But historically, always back. By the way, just for edification, is the vast majority of our rules have been here since the 1870s, like since the beginning, right, of the council. If you go back to the old rule books, most of it still says the same things. It's kind of interesting where this language came from. But nevertheless, would sit with you, start basically from rule 1 and kind of what does this all mean? And then there would be, you always hand wrote your orders out, right? So you would go and you would write up your order, and it would be a very official looking document I have some of the old ones, and they're really nice. And you would write up your order and you would give it to the clerk, and then it would go on the agenda. And this is sort of, now it's all just an email blur, but that's kind of what would happen. And the council president would go through all these things and answer questions, and this is where you sit, and this is when we meet, and this is what committees, and then you'd invariably have, what are your interests, and what committees do you want to sit on, and how does this all work? And then you would start getting into, these are the ethics rules, and you got to go sit with so-and-so, and, you should start making your rounds of talking to department heads, and you should sit with the law department, or, these are your different, things that you're supposed to do as a new counselor. And, just to get you acclimated in the 2-month period or so between the election and when you're sworn in, and then you're off to the races. Yeah.
Mm-hmm. I appreciate the context, and I appreciate, I always wondered, again, it's like, the quotes around it indicate, of course, the title. That makes sense now. It says, of course, that it shall be read during the first meeting of the newly elected council, which we currently don't do. Is that something that we want to require? Or do we want to change the language so that it is instead being shared or distributed, is one of my questions. Councilor Bacon?
Thank you, Madam Chair. I'm fine with the language change.
Okay. So shall be distributed by the president of the council to every newly elected city council.
Can we fix that typo?
Should it be counselor?
Yes, please.
Yes, okay. During the first meeting of that newly elected council?
Yeah.
Or at any time
Or
prior?
at any time prior. Yeah.
Okay.
Cool.
All right. Any further
I'll make a
discussion?
motion that we adopt the change to the rule.
So moved. Second, sorry.
All in favor?
Aye.
Okay, 19.
We probably should do a roll call for that one.
Oh, you're right. Thank you. Councilor Bacon?
Yes.
Councilor Murphy-Ramboletti?
Yes.
Councilor McGrath-Smith, yes. Okay. Item 19.
Motion to take up item 19.
Second.
All in favor?
Aye.
Aye.
Ms. McGrath-Smith ordered that 4E be revised to create a system that assigns a specific number to each order, allowing for better tracking across multiple committees and over time. Rule 4E is all city council orders introduced to the city council shall be numbered consecutively, and a log of all orders be kept by the city clerk and the council's clerk of committees, showing the order number, the date the order was brought before the city council, the action taken by the city council on the order, or the council committee or city department the order is referred to, the date the order is referred back from the committee or department, and the final action taken by the council. Yes, Councilor Bacon?
Yes, I would suggest that we table this because it's more complicated than it appears on face, especially when we're sending an order to more than one committee. this is going to be more complicated than just passing it and saying, let's put numbers. You know what I'm saying?
I would.
Oh, yeah, absolutely. I think this is something that's going to take some real discussion and could potentially require us inviting the clerk in.
Okay, yeah.
Yeah,
And
so
also
I think for-
talking to Solicitor Bissonnette. One of the things that has come up is that without you, if something is tracked by agenda number, it can become tricky over time to then track where that's gone and what's happened to it. So it's a question too around how this operates with Municode. And I think that it would hopefully, we would bring in multiple voices, principally the clerk. And I did speak to the clerk about it, and she said she would give some thought to what that better system might look like. And I know that both her and Jeffrey have done extensive Municode training. As that system has shifted, that might also affect that. So one of my thoughts is that we could, in effect, ask the clerk to provide either to come into council, come into Turner Rules, or just provide in writing their thoughts on whether they want to keep the system as is, or if there is a way that's more efficient.
Sure.
Yeah.
Okay. So,
Motion to table.
Second.
and communicate with the clerk.
Yeah. Motion to table and, get feedback from the clerk.
Okay. Was that a second, Councilor Bacon?
Yes, yes.
Okay. All in favor?
Aye.
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 Okay.
Motion to take item 20 off the table.
Second.
All in favor?
Aye.
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 McGrath-Smith ordered that Rule 4F be revised to align with modern practices. Rule 4F currently states co-signers of city council orders must call the city clerk to confirm that they do in fact want their name on that specific order. Proposed rule changes, the co-signers of city council orders must confirm with the city clerk to confirm that they do in fact want their name added as a co-signer to a specific order. So just effectively taking out the requirement that they call. They may not call. Sometimes you're just in the meeting, and so you're just, vocally saying it out loud in the body, or you're sending an email. There's multiple ways. You don't have to call the clerk in order to do it.
Yep.
Yeah. I'm sorry. I'll
Yes,
raise my
Councilor,
hand.
Councilor Bacon, yes.
Yeah, I think that's fine. I would just get rid of the second to confirm.
Okay, great. Love that.
No, so
Yep, so co-signers of city
co-signers of
council.
city council must confirm with the city clerk that they do want their name added. Just, you don't need to say to confirm again.
Okay, and remove in fact,
No.
Yeah, I mean, yeah.
or do you want to?
No, so she's saying that second confirm there. So must confirm with the city clerk to confirm. So just take out to confirm. Is that right, Councilor
Right.
Bacon?
Yes,
Okay.
yes.
There were
yes,
three.
thank
There
you.
were three.
There were
What
three.
fever
You like
dream was
that
I
word,
in when I was
confirm.
proposing this? I really wanted it confirmed. Okay, great. Okay, so the new proposed Rule 4E, co-signers of city council orders must confirm with the city clerk that they do in fact want their name added as a co-signer.
Motion to adopt as amended.
Second.
Okay, all in favor? Oh, roll call
Aye.
vote. Counselor Bacon.
Yes.
Counselor Murphy-Ramaletti.
Yes.
Counselor McGrath-Smith. Our names are really long.
Yes.
Just say.
You did it willingly.
That's true.
Motion to take up item 21. Oh, that's a
second.
long one too.
Okay, so this one, sorry, all in favor?
Aye.
So this is
Aye.
ordered the rule of Public Service and Human Resources Committee as described in section 9B4 and 9L and 9M be reviewed and revised. This is maybe the part that to me seems the most what we're not doing, but I'd also like to hear from others here. If Anderson Burgos is still here, I'm not sure if he had to leave earlier. Gosh knows we've been here for a while. Or also the city council assistant, if you want to speak to what's happening. Because currently, I'm going to just read it out loud. It says, the Public Service and Human Resources Committee. So we're already naming it in a way that like we're not often really naming it. when we talk about it, we call it public service, right? But it says Public Service and Human Resources Committee shall have jurisdiction over matters related to transportation, the affairs of the parks, recreation and forestry department, the appointment or election of any city official, matters related to city employees and personnel, permits for home occupation issued by the city council, and matters pertaining to the elderly, the geriatric authority, and the council on aging. That was amended September 5th, 2023. L, all new appointments and reappointments submitted to the city council for confirmation shall be referred to the Public Service and Human Resources Committee for its recommendation. And M, the Public Service and Human Resources Committee will be the committee that will represent the city council where requested by local, civic, fraternal, social, or business groups or organizations. It strikes me that this is not what we're doing with public service. And so I have big questions around a proposed revision. I think it makes sense to just remove M. I don't think when I asked, has this ever been followed? I think maybe it was, a revision at the time, trying to think about how to rebalance the committees, right? So that you could take some from one committee that was overburdened, had a massive jacket, let's spread the wealth, and give them a different purpose and expand their role so that some things that are being sent to public safety would be sent to public service instead. But M, to my knowledge, has never been followed. And I don't know if it really makes sense at all to have it, because I think all of us are representatives of the community and are often asked to represent the council in all different kinds of ways. L seems to be what we're really doing with it.
If I may.
Yes, Councilor Murphy-Ramboletti.
So, totally hear you on M. Although maybe I should enforce it because I'm not on public service, and then I wouldn't have to. No, I'm just kidding. So yes, I hear you on M. I'm sure at some point in time that was followed. I have no idea. I recognize that we don't necessarily discuss some of these certain things. Like, for example, the geriatric authority is not a thing anymore, so maybe we could amend that.
Are we sending permits for home occupation to public service?
That's a really good question. I don't think it's going
I
to.
don't think so.
I thought they was going to DGR.
Yeah.
And finance, some of them go to, right?
So it just doesn't strike me that. I think we should remove the geriatric authority. It doesn't exist anymore. It doesn't make sense for it to be here. Do they do council on aging?
Does council on aging come up a lot? I don't know. It's
Right.
more of a, I think because the council, I don't feel like we necessarily, maybe it's we don't remember that some of these things are listed, or we prefer to have the conversation in others. So rather than have a rule that we don't necessarily enforce and or follow, maybe it does make sense to get rid of it. There's also, I feel like, no harm in keeping some of that language. I will say that if home occupations usually go to DGR, then maybe that's where that should be. But other than that, I think transportation, the affairs of Parks and Rec, that's interesting. I feel like a lot of those have been going to public
They've been going to public
safety. But also, I would welcome feedback on, is public safety, do they have too much stuff in their jacket, and maybe public service doesn't. So I would say that it makes sense to keep the section about matters related to city employees and personnel. I think that's okay because that doesn't happen often, but it sort of aligns with the other things that we do that are related to appointments or stuff like that. So those are my thoughts. Thank you.
Counselor Bacon?
Yeah, I was just going to suggest that we get some feedback from the other committees and consider that before we change this, and we can circle back to it.
What is the best way to do that? Right. So like effectively too, and like this meeting went late and I totally understand it. I wonder if it just makes sense to table and then maybe
Reach
even-
out to the chairs, I would suggest.
yeah, and just sort of name like this is coming up, please come and weigh in, or send by email your thoughts. We'll read them
Yeah.
into the record.
Yeah, I
Right.
can work with Jeffrey on that
Okay.
if everyone's okay with that.
Yes, and I think that the same is true for another one coming up, that I just think it could be important to have a meeting that really focuses on this one and then another one that talks about just reorganizing the information, because sometimes a committee, stuff can get buried in the rules, right? When you have some information about a committee in one place, but then there's really this other section somewhere else in a different section, versus it all being streamlined into like, what does finance do? What does ordinance do? What does public safety do? And it actually being, and like maybe one section that
So-
these are things that applies to all committees. And then here are the things that are committee specific.
So could I offer a motion that we take 21 and 22 up as a package?
Or
read
do you wanna-
22,
Yeah,
and then table them for future
yeah.
feedback?
Second?
Any further discussion? Okay, all in favor?
Aye.
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 Okay. Okay. We have 23.
Oh my goodness.
Motion to take up item 23.
I'm making a new rule. Second?
All in favor?
Aye.
So the goal of this is that in the last meeting when we brought this up, there was a piece of this that we looked at in terms of shifting the minutes section, which used to be called the journal, and we just realized that it hadn't been talked about in a long time, and that it may or may not be what we're doing, right? It definitely doesn't necessarily align to the sections of the meeting as it's named. And so I wondered if this was the right order or if we should be moving things around, right? Do late filed orders get done last, right? Do they have to be addressed at some point earlier in the meeting? Does the president's report happen? What's happening now is that it happens 45 minutes into the meeting. Sometimes longer. One time it was like an hour and a half in. So does that make sense? Do we move that up?
No.
So I have questions around, are there things that should be shifted in terms of just where they are in the agenda? Or are there things that needed to be added or just need to be renamed or shifted because that's not what we're calling them, or we're not doing that anymore, or we're not doing that in that order?
Well, if I may,
Yes,
I
Councilor
think the
Bacon.
way it is fine, because we can suspend rules and take something out of order anytime, and you do it on occasion. But it's not happening so much that it would seem to indicate you should change up the whole thing.
Councilor Murphy-Morletti. Thank you, Councilor Bacon.
The only one that I would suggest, I guess, is sometimes it is weird for me as the president that the president's report's like halfway through the meeting, just because I feel like there are some things that I want to like address beforehand, or or things are like, I know that things are coming up and it might get mentioned, so I just want to address those things first. I'm not feeling like super strong one way or the other, but that's the only one I've had that thought when I'm like running the meeting, is like, oh wow, we're like an hour and 15 minutes in. I wish I brought this up beforehand. That's the only one. But yeah, I don't feel passionately.
Would you want it right before public comment or after public comment?
Maybe after public comment. I do want to give the public like that,
Yeah.
I also wonder about the presentation of petitions, memorials, and oh my gosh,
Remonstrances.
remonstrances, right? Deep apologies, which we could probably all start with.
Those words I don't think have ever been on an agenda ever.
But those get done before. Like we're not gonna make someone wait. They're there for a memorial. Like we call them really proclamations, right? But we always do it at the beginning. So I wondered too if it made sense to move president's report and the next one, presentations, up to right after public comment.
But presentations is already number 3.
Yeah, so this is where it gets weird, right? Presentations and
I think
reports
it's-
by invitation versus,
The petitions is.
but memorials? That sounds to me like the moments of silence that we do. But am I wrong? Or does it mean something else?
That seems. Is that
I wonder if that's really, I don't think it really actually meant that, but maybe. But we've never really looked at it that way. I'm almost wondering, is this something to do with like old requests to be in like a city graveyard or something? Like the city has old graveyards from way back when where maybe you would request that, you know, Old Man Jenkins be allowed to be buried in the city cemetery on, isn't there one out in Smith's Ferry or something that is an old city cemetery? I mean, it could be something like that, like those type of requests.
Interesting.
Yeah,
Again, this is like when we're in documents
that definitely needs to
are
be
really
updated.
old. And so like, it's like, again, it's like, what does that word even mean? What it means now might be
Exactly.
very different from what it meant then. We're
Exactly.
guessing.
Exactly.
So can I make a motion that we let our president think about where she wants her items and we can table it and then finish it off next time?
I like that motion. I will second it.
All in favor?
Aye.
Aye.
Okay. So just chair's prerogative here. It's almost 9:30.
Yeah, I was going to ask that all the other ones be
And
tabled.
I'm just,
That's okay.
if it's fine, I would like us to be able
Yeah.
to table the remaining items. I think we did like yeoman's work tonight. We did really good work. We went through a lot.
I'll
and I
make
think
a
it-
motion to
Thank you.
table items 24 through 27, or leave them on the table, I should say.
Yes. Okay.
Second.
If we're leaving them on the table, do I have to read them out loud?
No,
Okay. Yay. All right. So all in favor?
Aye.
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 And then just motion to adjourn.
Motion to adjourn.
Second.
All in favor?
Aye.
Aye. Thank you all.
Yeah. Good night.
Good night, everybody.
Good meeting.
Night.
Good
Everybody,
night.
good night.
Hey, I didn't even go on to.